is a case, review petition has been filed in the year 2022.
Lordship.
And every time an adjournment is being sought. And therefore, I fixed the last date you see was fixed in the month of 3 months back.
Lordship.
So that you are in a position to argue in it. Otherwise, we are going to close this. These are things which cannot be kept on taking up in this manner.
Lordship, are you advocate,
You are not in the file an appeal.
Lordship?
Read the file. We'll take it up at 2. But this is nothing to do.
Lordship.
May I plead the lordship, my lord, I pray for listing of a eviction matter tomorrow, my lord, motion matter, my lord. Obliged, my lord.
Unlisted means a new matter.
New matter, my lord. Obliged, my lord.
Please, your lordship. Lordship, I beg to mention for listing on 19th, lordship, writ petition regarding land revenue
For admission.
admission, lordship. On 19th, my lord.
Why?
Lordship, if your lordship is convenient.
What is the urgency?
Lordship, the petitioners before your lordship with a limited relief, my lord. The
Huh?
petitioners have submitted an application way back in 2018, lordship, but the application has not been considered by the concerned authorities. They yet to arrive at a logical conclusion.
You filed what application?
Application for cancellation of a mutation, lordship. Illegal mutation, lordship. Then the application is still pending, lordship.
Okay, we take it up today. Today? At 2 o'clock? Take it up today.
Lordship.
You have urgency. It is a small prayer.
Lordship.
Take it up today.
At 2, lordship.
2?
Right.
May I please, your lordship, pray for listing of a pending writ petition, my lord. However, my lord, the petitioner's right in Article 300A has been violated, my lord. Like,
What right?
my lord, Article 300A right has been violated, my lord. My lord, petitioner's land has been acquired for embankment, extension of an embankment, my lord. However, my lord, the petitioner has not been paid compensation for the same.
এখন কি হল এটো কাম নকরেন What is this? When was it last listed?
My lord, 27/9/2023.
Chalo, we have it on 27/9/2024.
Obliged.
I beg to mention an IA for modification. The main matter is listed tomorrow. But the IA has been filed yesterday. Therefore, lordship may allow listing
Okay.
tomorrow.
If it has been listed, then ask the registry to list it.
Yes, lordship. Item 35 as item 35 tomorrow.
May it please your lordship. Lordship, with regard to item number 11, I have filed an affidavit. Lordship, that is not on part of the record, your lordship. That may be called for. Oblige, your lordship.
May I please, your lordship? Lordship, I beg to mention for listing a WFC. Lordship, it was last posting on 21/6/2024.
What is the matter about?
PMA Pakka Construction, lordship. PMOI Pakka Construction, lordship.
What is the urgency?
Lordship, Waller got already houses, but except petitioner's lordship. And the duration is going to finish on lordship
Okay, 27th.
27 of last year.
Yes, Mr. Chaudhary. What do you say on the locus?
My lord, to be honest, my lord, I thought I will take note of lordship's concern in the matter. Then accordingly, I'll address your lordships on another day. If your lordships would kindly indicate which all are the area lordship wants us to address your lordships. In that case, I'll do it. In fact, my lord, our involvement.
Otherwise, your judgment is ready. Judgment is ready. It's ready. It's only on that aspect. Because that day, Mr. Dhor was pointing out that judgment.
Ayub Khan's case.
Huh?
Nur Khan Ayub Khan.
Now, the concern out here is this.
Yes.
If we just permit, because I have to touch Justice Sumanshyam's order also in the
Yes.
order. Then how do you take care of permitting this and challenge to a caste certificate by a person who is otherwise not affected? Because in Ayub Khan's, there is a specific reference to that effect. Yes, or that those persons can very well come. Any other person who is otherwise affected because their rights are being affected. Somebody, the others' rights are being affected because their reservation is being taken away or their opportunity which is there is being taken away. Yes, it is further stated that if those persons are not in a position to come, a public spirited person can come. But in this case, it is on the question of a FIR being registered on 7/1/2020.
Charges भी है. Charges भी.
First FIR was registered on 3/1/2020. Subsequently, this on 7/1/2020, this section was incorporated.
And it's
She applied for a caste certificate on 4/8/2021, 20. And thereafter she got it. That is another aspect of it. But whether it is not the subject matter of a trial, as of now, because now you have already, the charge sheet has been given. So nothing survives as regards the problem of anticipatory bail. That is not there. But is it not a case where it's a question of trial where you may have to you cross-examine them as regards how can you be, all these aspects will come in. But can you go for a caste certificate in view of that judgment wherein it says who are the people who can challenge the caste certificate? That is one. The second aspect is as regards, there are three aspects which have been brought by Ramesh Bhai. First, as to whether they are living with the mother. Second, which is most pertinent, having born in a family where the father is of the forward caste and having advantages thereof, then the question comes about the deprivation. But if there is no advantage, where is the question of the second part? The second limb, where does it come in? The second limb will be only in the case of an advantage. Just for example, in the Kerala full bench judgment, which have been approved in Ramesh Bhai. There also it is mentioned that if it is a case where a person, just for example, the woman out there, the baby is in the womb, or she had a divorce at a very tender age, or the father had died, then you can't deprive him. Which touches on the question of whether this is a case of an involuntarily acceptance in that community. If it is a voluntary, just for example, in the case of Valsama, it's a case of voluntary. In the case of Anjan Kumar, it is a case of voluntary, where he has studied all along, lived with the father, parents of the father, and after living with the parents of the father, then he comes up out here that I am with the mother and as such give me the mother's caste certificate. In the case of Valsama, this is the woman out there who had all along the proper upbringing in a forward caste society. And thereupon, she has now been brought in. She got married out there. And then that is the basis on which it has been said that where is your deprivation? You have all along been brought up. Number three, the third condition out there, which is in Ramesh Bhai, is that whether the community as well as the other people in the community has accepted.
yes, madam.
Now, what is seen is out here, if you have seen the vigilance report, the vigilance report says that he had inquired with the community, other people of the community only as regards whether these people have been suffered deprivation. What was the yardstick is? As to whether in the other people in the community have accepted them also as ST. That was never done. If you see the vigilance report, that is also absolutely vague on that. I have contacted some people. There is no statement recorded. Nothing is there. But they say that whether these people have suffered deprivation, that is not the what the other people will know. What is to be seen as to whether they had accepted. Because if we see the third limb of Ramesh Bhai, now the most important pertinent question out here is the reservation given on the basis of blood, genes, of a forward caste, or is it given on the basis of backwardness? Now, if you see the judgment of the Constitution bench in the case of this, what is the name with? The name was there.
This one,
No, not that one. This is a judgment by Justice Arun Mishra. This is on the 5th schedule of the Constitution, wherein the question was, I think it is in the state of Madhya Pradesh or something, Andhra Pradesh. They made 100% ST reservation. Now, could it be done? So then in that regard, it was stated, no, you can't do it in this manner. But there in paragraph number 106, this is the case of Sebrolo Leela Prasad Rao versus State of AP. It's a Constitution bench judgment reported in 2021 11 SCC 401. Wherein the
11.
Constitution bench observes that paragraph 105 and 106 why the reservation is being granted to scheduled tribes. The use of the words is the benefits which are there in the society had not percolated to these people. And as such, it is on the basis of that there is a deprivation. Now, if we touch that with the Ramesh Bhai and see the deprivation on basis of an involuntary act, wouldn't that be a deprivation on the face of it? Thereafter, if you see, because the order is being passed on the basis of education being provided, and prior to that, another aspect. Another aspect is being taken that this woman concerned, the petitioner number 2, she's an, what do you call,
Assam Police.
Assam Police gazetted officer and all. But the fact that she is a scheduled tribe is not in question. Whether she has cut off her links with that family is also immaterial. Unless there is a vigilance report to that effect, not to her, but as regard the children, that these children are brought up by the grandparents of the father, which is not there. Now, whether she had a good upbringing in her family, everything are there, she received everything out there. But is it individual centric? However, if you see the judgment of the Supreme Court in Indra Swani, more particularly at paragraph number 779, it categorically mentions that this is a homogeneous class. So immaterial of how much benefit a person gets is immaterial. And this aspect has been further explained by another judgment in the case of, this is a very beautifully written judgment of Chief Justice of India in the case of Neil Orello News versus the Union of India, 2024 SCC, page 1, wherein in paragraph number 31 and 32 is very relevant, wherein he categorically says on the basis of N.M. Thomas that this is individual centric. It is not individual, it is
Or
group centric.
homogeneous.
Then he further explains that a person may be very well having a good education in a good school. But if that education may be there, but that person, when he comes back home, when he asks his father or mother or any of his community how it is to be taken or what further things can be known about this aspect, they can't say. This itself is a deprivation. Then you further see in that judgment, another judgment is B.K. Pavitra 1.
Pavitra.
That in that judgment, the Supreme Court observes the judgment is otherwise ready. Yes, 2019-16 SCC. More particularly at paragraph number 16 SCC, page 1 to 9. More particularly at paragraph number 134 and 135. As to what is the basis on which you are to construe them as to be educationally backward or forward. It says it's well settled that existing inequalities in a society can lead to seemingly neutral system discriminating in favor of the privileged candidates. As Mark Galanter notes, three broad kinds of resources are necessary to produce the results in competitive exams, that is to qualify as indicators of merit: economic resources, social and cultural resources, and there he says network of context, confidence, guidance, advice, and information. Then the first two criteria are evidently not products of a candidate's own efforts, but rather the structural conditions in which they are born. By the addition of the upliftment of SC/ST in the moral compass of the merit in the government, appointments and promotion, the Constitution mitigates the risk that the lack of the first two criteria will perpetuate the structural inequalities existing in the society. Now, these are the broad parameters on which I would like you to address.
Yeah.
And,
I'll try to assist the order.
and why is the caste certificate required? You don't require it for the SC/ST Act. You don't require a caste certificate. Caste certificate is only required for the purpose of granting benefits under 15(4), 16(4), or other benefits which are there as per the Constitution. Somebody wants to contest an election and all these things being a scheduled tribe. These reservations which are there, so all the benefits of the
Admission to educational institution.
basing on the socio-economic democracy which B.R. Ambedkar taught while giving his last lecture before the Constitution came in. So this is on the basis of a socio-economic democracy. So if that be so, the caste certificate, if it is required in this manner, that aspect, why it is required, does it have any impact on the SC/ST? Then again, it touches on your locus standi.
I got it.
Well, Thursday, judgment is ready. Only on that aspect why I wanted to ask you. Other aspects is okay.
Thursday, I will be out of station. Can it have it, like, have it on Tuesday next week? Tuesday, I have a difficulty.
No, I have nothing to hear you. Nothing to hear. I'm nothing to hear you. I'm only here to ask
Not to be
them
keep it
only
of
that,
testing.
more particularly touching on other aspects is other on
Lordship has
the-
already seen all the law.
the other
Hopefully-
aspects I've looked into it. This is how you analyze that deprivation. If there is no advantages, where is the deprivation? How can you prove a deprivation? You can't prove something negative. You can prove something. Just for example, in Anjan Kumar, this person all along was with the father.
Correct.
And thereafter he goes and wants to take the shelter of the mother's ST status. Then you have to show, yes, there is a deprivation. This is how I felt after having been brought in. And these are all additional an
Facets.
additional requirement being put by the Supreme Court in order to that, so that there is no misuse.
Correct.
But if it is a case of involuntary act, can you incorporate that condition? Because there is no advantage. Therefore, the word used is having the advantages beyond the being born in a forward cast. The deprivation, he has to prove the deprivation. But if there is no advantage, where is the question of deprivation? So that is on that.
Follow. Lordship, the deprivation is linked to how you're brought up. Twin test. If you're an offspring, it's how you're brought up and whether you're accepted. If you're brought up with deprivation, then you belong to the community that has deprivation. If you're brought up as a forward, then you don't have the deprivation. So test is how you're brought
If
up.
you are brought in forward also, you are brought in forward, you are to prove the deprivation.
Correct,
Correct.
Your Lordship.
That might be a case.
Correct.
In a case where you are being brought up in a family, let us take the example of a nowadays, this is, you see, every time the law is changing in respect to this. In 1940s, it is being taken that as regards the patriarchal type of society, where because of the fact that the husband used to be the provider. Things changed in 1996 in Balsama, where the Supreme Court says that yes, all these things. And that was the result why Ramesh Bhai said that yes, it cannot be said to be an absolute presumption. It has to be a strong presumption. But that is also in 2011. Now you're taking into account the recent judgments on this army and navy that where ladies are being Can you say, just for example, in a woman out there who belongs to the SC, she is a very highly she's in a IS officer, a cabinet secretary. The husband doesn't do anything, and the wife and the children stay with the wife, mother, and the husband also stays there. Then how do you say that? Can you say that, it has not been brought up? There might be circumstances when now, because now it is not it is nothing that one cannot conceive that it is a child is being brought up by the mother also. Absolutely, when the husband is there also. Things are changing or evolving on that aspect.
Anyway, on Tuesday, will it not Thursday? Only because I miss out on the discourse on law.
You see, the Thursday I've got so many matters. Or not okay, Thursday.
Obliged.
17th I've got
Obliged.
lots of matters.
Obliged.
Not this Thursday, next.
No, excellent. Yes.
On
Yes,
19th.
yes.
Yeah.
Obliged.
Having heard the learned counsels appearing on behalf of the parties, the matters is again fixed on 19/9/2024. For this court heard the instant petition on 13/8/2024 at length. At the time of preparing the judgment, certain aspects came into light, which this court, for the interest of justice, felt it necessary to point it out to the counsels appearing on behalf of the parties. This court had pointed out those aspects, and the counsel appearing on behalf of the parties have submitted that they would like to further address this aspect on 19/9/2024. Listing at the top of the list. Yes, what is this?
Yes, Lordship, I appear for the petitioner. This is income tax matter, Lordships, and this is a second round of litigation before your Lordships.
Hmm.
So,
What are you challenging?
so Lordship, I am challenging the order passed under section 148A(d) of the Income Tax Act. So, Lordship, what has happened in this matter? A show cause notice was issued to me under section 148A, alleging that I have made a bogus purchase to a XYZ part to a party. I replied to the notice stating that your information is wrong because I have not made any purchase transaction with the said party, but I have made a sale transaction. So the prima facie, the information basis which the notice was issued, that itself was wrong. In the order, in the first round of the order, Lordship, if Lordships can come to page 62. Firstly, I
701.
take Lordships to the show cause notice at page
Which
50.
petition, Mr. Counsel?
Abhishek Mittal. It is
Both are Abhishek Mittal.
7014.
701. Yes. Tell me.
Page 50, Lordships. The show cause notice which was issued to me. Page 50 is the show cause notice, 51 is the annexure, the reason given. If Lordships can have the first paragraph. Information has been received from inside portal under high risk related information that Shri Abhishek Mittal had made bogus purchases from Messrs Swastik Traders, proprietor so and so, of ₹4 25,86,700 during financial year 17-18.
No, you are reading page 50.
51.
Why
Annexure.
50?
50 is the show cause notice and the annexure is at 51. Annexure to show cause notice.
Yes.
So first paragraph. Information has been received from inside portal under high risk case related information that Shri Abhishek Mittal had made bogus purchases from Messrs Swastik Traders, proprietor so and so, ₹4 so and so during financial year 17-18. So Lordship, under the section 148, reassessment proceedings can be done on the basis of the income, on the basis of information that is flagged from the portal. So the information here, what the officer has received, that itself is wrong. He is alleged as a bogus purchase. I replied to him stating
No,
that
what did you say? What did you say? 148 means?
148 is reassessment proceedings. Lordship, there is an assessment proceedings, which are the like a normal, I file a return of income and then the officer does the assessment. In my case, that has already been done. Reassessment is like a special power which has been given to income tax officers, where like if they come across with the information later on that income has escaped assessment, then they can do reassessment proceedings. So unlike normal assessment where they can do assessment for examination purpose also, reassessment they have to be a specific concrete information that a income has escaped assessment. And it is also settled principle that it can't be barely an inquiry proceeding. Just to make an inquiry, you cannot initiate reassessment proceedings. So that is the law. Lordships want I have the compilation. I have annexed the section. I can take the Lordships to the sections first.
Where is the compilation?
In the file, it is already there, Lordships. This is a volume 2, but first volume is already furnished, Lordships.
I don't have the first volume.
In the Abhinav with like, I believe in the second file, it may be there then.
No second file.
I request my friend then can hand over the first volume also, Lordships.
Yes.
Yes, Lordships. Page 3 of the compilation, that is section 148. So for doing reassessment, they will have to issue a notice to me first.
Then?
So before 148 notice, they have to issue a show cause notice under section 148A. That is at page 5, providing me the reasons. May I read, Lordship?
Then?
So they have to first, what will be the information for the purpose of section 148A that is defined under the explanation 1 to section 148.
Where?
It is at page 3, Lordships, explanation 1. For the purpose of this section and section 148A, the information with the assessing officer which suggests that
Page 3.
page 3,
For the
explanation 1.
purpose of this section and section, the information which the assessing officer which suggests that the income chargeable as in a means and information flagged in the case of the SSC for the lender in the accordance with the risk management strategy formulated by the board. Any final objection raised by the controller and auditor general to the effect that the assessment in case of Iman has been made in accordance with the area.
So present case is under subclause 1, Lordship. There is no dispute about that. So under section 148A, they have to issue a notice to me providing this information. And if before that officer feels that he needs to do some inquiry with respect to information, that safeguard is also there.
Where is the mention that there is a requirement of providing you the information?
In the section 148A, Lordships.
Let us see. Conduct any inquiry if
yes.
required with the approval of the specified area with respect to the information which suggests here. Provide an opportunity to be heard to the SSC with the prior approval of the so-and-so by serving him a notice to show cause within such time as may be specified, being not less than 7 days but not exceeding 30 days on which such notice is issued and or such time as may be extended by him on the basis of an application in this behalf as to why the notice should not be issued on the basis of interest which suggests that income chargeable to tax have escaped assessment in so-and-so. Where is the mention that there is a requirement of giving you the information?
In the show cause notice, he has to give the Lordship. That's what it states, that he has to serve a notice to me, provide an opportunity, serve a notice to me, why it should not be issued on the basis of information. So I have to.
He has. Why
So that is
the requirement that he has to provide you that information specific?
That is the mandate under section.
There is not the mandate. Where is the mandate? Show me.
Lordships, it's that Supreme Court also has now laid down guidelines with respect to this section where they have discussed this.
Let us see that. Where?
Yes, that is at page, this second judgment, Lordships. It is, and the relevant portion starts from page 17.
Of the second volume?
First volume. Page 17, paragraph 15. Lordship, have the paragraph 15.
Paragraph 15.
Paragraph 15. May I read, Lordships?
Yes.
Page 17, paragraph 15. It cannot be disputed that by substitution of section 147 to 151 of the Income Tax Act by the Finance Act 21, radical and informative changes are made governing the procedure for reassessment proceedings, amended sections 147 to 149 and section 151 of the IT Act prescribe the procedure governing initiation of reassessment proceedings. However, for several reasons, the same gave rise to numerous litigations and the reopenings were challenged inter alia on the ground such as no valid reason to believe, no tangible reliable material information in possession of the assessing officer leading to formation of belief that income has escaped assessment, no inquiry being conducted by the assessing officer prior to issuance of notice, and reopening is based on change of opinion of the assessing officer. And lastly, the mandatory procedure laid down by this court in the case of GK and dive shifts has not been followed. Further, pre-Finance Act 2021, the reopening was permissible for a maximum period up to 6 years and in some cases beyond even 6 years leading to uncertainty for a considerable time. Therefore, Parliament thought it fit to amend the Income Tax Act to simplify the tax administration, ease compliances and reduce litigation. Therefore, with a view to achieve the said object, by the Finance Act 21, sections 147 to 149 and 151 have been substituted. Under the substituted provisions of the Income Tax Finance Act 21, no notice under section 148 of the IT Act can be issued without following the procedure prescribed under section 148 of the IT Act. Along with the notice under section 148 of the IT Act, the assessing officer is required to serve the order passed under section 148 of the Act Section 148A of the IT Act is a new provision which is in the nature of a condition precedent. Introduction of Section 148 of the IT Act can be thus be said to be a game changer with the aim to achieve the ultimate object of simplifying the tax administration, ease compliance, and reduce litigation. But prior to Pre-Finance Act 21, while reopening and assessment, the procedure of giving the reasons for reopening and an opportunity to the assessee and the decision of the objectives were required to be followed as per the judgment of this court. So prior to amendment as per the judgment, however, by way of Section 148A, the procedure has now been streamlined and simplified. It provides that before issuing any notice under Section 148, the assessing officer shall conduct an inquiry if required with the approval of a specified authority with respect to information which suggests that the income chargeable to tax has escaped assessment, provide an opportunity of being heard to the assessee with the prior approval of a specified authority, consider the reply of the assessee furnished, if any, in response to the show cause notice referred to in clause B, and fourth, decide on the basis of material available on record, including reply of the assessee as to whether or not it is a fit case to issue a notice under Section 148 of the IT Act, and the AO is required to pass a specific order within the time stipulated. Then Lordship's paragraph 22. So the 20 also, therefore, all safeguards are provided before
Where
notice.
is it mentioned that you have to be provided with the information?
Lordship may see para 18, but prior to Pre-Finance Act 21, while reopening an assessment, the procedure of giving the reasons for reopening.
Yeah, Mr. Jain, that is
Yes.
not the question which I am asking you.
Yes.
Where is the requirement that you have to be provided with that information?
So the show
What is to
cause,
be here that he may have information on which it has escaped assessment?
yes.
He may say that this is the amount of information which have here, but he is not going to required to provide you from where the information has come.
So I am not saying where the information come, because the section itself says from where the information should flow, but he is required to issue a show cause notice to me, providing me an opportunity of being heard with why he wants to reopen. He has to give me a reason, and to that I am supposed to file a reply to that.
So this notice is being given under 148A.
So, but if the reason itself is wrong, then how
What
he can
reason?
proceed?
Why
The
you are
reason
saying
he
the
is-
reason? Is
He has
wrong?
made a reason that I have made a bogus purchase, but actually I have made a sale
So there
transaction with
you,
them.
why you are not replying there?
I have replied. Lordship,
Then
I have
what
replied.
happened?
Yes, I replied. The order, Lordships, is at
Where is your reply?
my reply is at page 53.
Page 55.
Page 55.
Then
I replied. Then he passed the order that is at page 62, and the relevant portion is at 64.
a show cause
Accordingly-
notice was issued in respect to the SSC prior approval of AO in respect of Iman is filed a written submission online, which is seen from the SSC, where it is seen that the SSC did not purchase the alleged so and so during the financial year so and so. It is rather strange that SSC has made the exact sale amount towards the sale of Kabuli Sana so and so, so and so. In the instant case, as seen, there is a strong indication that the income chargeable to tax has escaped assessment. I find it was. Then what is wrong?
Yes, it was wrong. Then I challenged this order before your Lordships, and that order is at page 65. The
Huh?
observations are at page 67.
Then
It was remanded back.
then
Page
it is there
67.
that we are not interfering with the order for any other reason other than what is indicated. What is the reason?
Before
interfering-
Lordships can have para
interfere
5.
with- Remand the matter for an appropriate order to be passed as required under law as regards satisfaction. While
Lordship can have para 5
convert
and
the
7.
allegations made in the so-called notice from a burger to that of a sale after sale of Iman and instead, and also instead of arriving at any satisfaction, the assistant commissioner merely expressed that it is rather strange. Goodness, what is
So he
wrong?
passed the another order.
Then what happened?
Then he passed the second order. Firstly, Lordships, he forgot that there is a remand and he is required to pass a fresh order. He issued us notice unto me under 142. We started the assessment proceedings. I replied to him that firstly you are required to pass an order, then he passed the order. So it is even barred by limitation also now.
No barred by limitation. The matters have been pending out here. Anyways, where is the second notice?
Second is at page 60, page 78.
Letter order under so and so. The instant case is the proceedings under so and so, so and so, so and so. The insight here, the SSC was agreed by the swearer and petition here. The honorable court passed the order. And
Lordship, sir, page
conviction of
17.
purchase for Iman. This, that is pursuant to the above order remanding the matter to proceed de novo from the stage of suppose notice in hereby passed. And accordingly, therefore, the limitation period get extended as per the flag risk so and so on remand. In the examination of remand, director of remand, the same date was confirmed. Then so and
So,
so. Then so and so. From the above deposition admission of so and so, this issue remand. Yes. So what is there? What is
So
wrong?
Lordship, he admits that the information is incorrect. He admits that actually I have made a sale transaction with the party and it is not the purchase transaction. But he says the honorable court has given a liberty to him that he can convert the allegation and he can now decide the issue afresh. That is my grievance, Lordships. And what are the reasons which he is giving? Page 79, if Lordships can have. Page 79, first paragraph, last 3 lines. As the assessee's name surfaced from the list of the parties with whom these fictitious entities had arranged bogus transactions, therefore the information had been uploaded to the Insight portal and was ticked under the category bogus purchase. He admits that the information was of bogus purchase. Now, Lordships, in their affidavit, now they at
Okay,
3
but
times. Yes.
Mr. Jain, we are not
Yes.
on this agreement. We are on this thing. What is
Yes.
wrong?
Yes.
Why this order? What has happened is because of this with this this court ought not to have at all interfered by the order dated 11/5/2022. Yes, you have a right under 148A, how it is the reassessment. Against that, you have an appellate provision. What is
No,
all
against this, there is no appeal provision, Lordships. Against
Why
this,
not?
there is no appeal. It's only against the assessment order that I have an appeal
That is what,
order.
no, after the reassessment is been done, proceedings is initiated and then it is being done, then there will be an assessment order.
No,
Against
so
that assessment order, you can
So,
very well file an
Lordship,
appeal.
there are two things, whether he can do the reassessment and whether what he does in the reassessment. So whether he can do the reassessment or not, that is under challenge. What he does in the reassessment, that I can challenge in appeal, but whether he can do the reassessment and
What
that
is
also,
wrong with the order?
because now he is converting the allegation and that again is, there is a division bench judgment of this honorable court directly on this point. When the reason itself is of wrong, then nothing survives under 148. To my
It is,
compilation,
that is a division bench judgment where? Show me that.
it's at compilation 1, Lordships.
No, why you are saying that the reason is wrong? What is the
Because
wrong?
he has alleged I have made a bogus purchase, but I
Yeah.
have made a sale transaction. So the reason itself is wrong. So I'm denied the opportunity. Division bench judgment, serial number 3, Lordships, page 26.
We observe that the assessee in his petition area has made mention about the purchase the year, whereas it is relevant and important in the larger macroscope of the internet of bogus selling, and thus in this case both the purchase and the suspect and there definitely would have been incurring a brokerage commission for arrangement of implementation. Chargeable to tax the speed assessment. 7. Kindly come to page 90.
Page 90, yes. Yes, Lordship.
Thus, in the present issue, here the purchase as well as the sales are all doubtful.
So he has gone now in the order. He couldn't. He should have mentioned all this in the show cause notice. So now
Why?
he is converting the allegation.
No,
Basis the sale
he
was
says
going
that
to
it
be-
is bogus.
So now, Lordship, he is going from the sale that since you have made a bogus sale, so that's why
Is
your
this
purchase is
the
also.
only challenge? We dismiss your petition. Go.
The Lordship can have the compilation then, the judgment of this honorable court.
That is for the division bench.
The Lordship and serial number 3, Lordships.
No.
Compilation 1. If he is
No,
converting
you
the
don't have a
allegation
case.
despite there being a specific
You
direction.
don't have a case, Mr. Jain.
Lordship, if then this Supreme Court procedure has been laid down that you
Let
have to
the
follow.
matter be taken up by the Supreme Court for that. Whenever you go to Supreme Court,
Lordship can just have a judgment of this division bench for a moment.
not
I request.
necessary. Show it to the division bench that this court didn't look into it. The order, you see, what is being done by you, you have converted this 148A proceedings into a proceedings under 148. Kindly see 148. There is a
Yes.
difference out there. Why 147, 148A was brought in?
Yes.
148A was brought in that unnecessarily there should not be this 148 proceedings should be done. So
Yes.
therefore, there is a requirement of having an initial inquiry so
Yes.
that before going into a 148 proceedings, because in view of earlier 1PA, this drive shaft's judgment, you were required to file your return and then you can say. That was the basic reason. And as such, 148A was brought in only for the simplified reason to that effect that kindly give you an opportunity if you have anything to say, look into it, and then you go ahead with the 148A, 148 proceedings. Then once your 148 proceedings are there, because 148A does not say anything about reasons to believe.
Lordship, 148A says me to give a show cause notice with the.
Where does it say about reasons to believe?
Because the
Mr.
show cause
Jain,
notice says that he has to give me an
What
opportunity.
Mr. Jain,
Yes.
does 148A says about reasons to believe?
But then, Lordship, what we noticeable issue to me?
Question. As 148A says about reasons to believe? No.
Lordship, in my submission, it does say
No. 148 says.
148A
148A. Does it say
Yes.
about reasons to believe? No.
gives he has to give me a notice. So 148 says that he has to
Jain,
pass
if
an
you don't
approval.
understand the question, then take your seat. Let me dictate the judgment.
Lordship just can have a order of
No,
the
I am
division
not.
bench.
I am not. Yes, Mr. Kyle.
Proceedings on to page 90.
Hmm?
Page 90.
Page
Page 90.
90. In fact, what has happened is they have converted these proceedings into 148 by the manner in which it is being functioning.
Yes.
You see, 148A is only is a safeguard. It's nothing more than that. That you see, 148 is a drastic provision. Because if it is done, you have to file your returns and all these things. So under such circumstances, 148A was brought in. That you have an initial inquiry, and after doing this initial inquiry, whatever you feel, you find that yes, there's some case made out, and on the basis of which you may have reasons to believe, you can go ahead with the 148 proceedings. That's but here what has happened is the interference, with due respect to my coordinate bench, the interference which was made at that point of time was only a preliminary inquiry.
Yes, that was a preliminary.
The 148A cannot be a concept to that effect that it has to be treated as if it's like a 148. Because there you also have. You see 148. Kindly see 148, how it is being used.
For making any assessment, reassessment or recomputation.
Income chargeable to tax and therefore
The assessing officer shall serve the SCCA notice along with copy of the order passed. If required under section, under clause B of section 148A, requiring him to furnish which Such period.
before making assessment, reassessment and recomputation under section 147 and subject to the provisions of section 148A, the assessing officer shall serve upon the notice along with a copy of the order passed if required under so and so, requiring him to furnish within such period as may be specified a return of the income or the income of any person in respect of which he is assessable under the act during the previous year corresponding to the relevant assessment year in the prescribed form and verified in the prescribed manner, and setting forth such particulars as may be prescribed and the provisions of the act here. Now, once 148 is being done, there is no scope of filing any reply or anything. What is required is that you have to file your return. And thereupon, you can very well challenge it
Yes.
on the ground that you have this one. Finally, see 148A issue of notice, but prior to that one day, here. If any income assessment has escaped assessment on income. So now the reasons to believe aspect is gone
Yes.
because of the preliminary inquiry being made. Isn't it? So earlier, which was there in 147, that he has to have reasons to believe.
Yes.
Not there. So therefore, the challenge can be made on what basis?
Lordship, he has not
You,
met
Mr.
any.
Jain, take your seat. I'm not there. You have nothing to. How can it be challenged now?
You cannot tell, Lordship, they have to challenge the assessment before that period of time.
No. Just for example, 148A had not been compliant. 148A does not require any information to be provided.
Yes.
It does not say so.
Yes, sir.
Conduct an inquiry. The assessing officer shall, before issuing a notice under 148,
Yeah.
conduct any inquiry if required with the prior approval of the specified authority with respect to the information which suggests that income chargeable to tax has escaped assessment.
Yes, sir.
So this is the source of, and he will make an inquiry. Now, in making an inquiry, he will have to issue a notice to the assessee with the, and provide a hearing, provide an opportunity of here with the prior approval of the specified authority by serving him a notice to show cause within such time as may be specified in the notice before, not so and so, but not exceeding 30 days from the date on which is issued, or such time as may be extended by him on the basis of an application in this behalf as to why a notice under section 148 should not be. So therefore, after the bringing into effect of section 148A, the question of reasons to believe which was earlier to be recorded, that is no longer there. That has been done away with by making a preliminary inquiry. Now, now this 148A notice, earlier 148 notice had to be issued with the prior approval, na? For the purpose of this section, when a search is assessing is satisfied with the prior approval of the Iman that may any influence or Iman. So the approval which was required under 148 earlier, that is not required now. It will be, this approval will be given under 148A. So here it will be given by whom?
It will be by the assessing officer, 148A.
It's under section 151, Lordship.
In an assessment, 152, no, 151. Specified authority for the purpose of section 148 and 148 shall be the principal commissioner, principal director if they less in Iman and principal Iman or where there is no principal in the. So this is under 151. Adopting Iman, provided that the provisions of section shall not apply in a case where a search initiated under Iman. Says it. Yes, Mr. Jain. Now tell me which judgment you are referring to.
Lordship, just for a minute, if Lordships can once again come to that Supreme Court judgment, which I had just cited, page para 26, the conclusion, where the Supreme Court has given direction that you provide information to the assessee. Para 26, first point. The impugned section 148 notices issued to the respective assessees which were issued under unamended section 148 of the IT Act, which were the subject matter of writ petition before the various respective high courts, shall be deemed to have been issued under section 148 of the IT Act as substituted by Finance Act 21 and constitute or treated to be show cause notices in terms of section 148 AB. The assessing officer shall within 30 days from today provide to the respective assessees information and material relied upon by the revenue so that assessees can reply to the show cause notices within 2 weeks thereafter. So Supreme Court has given direction that you provide information and the material.
But where is the mandate of the constitution, of the section that to provide information?
Lordships, under 148, so firstly, the basis of information, if the officer desires, he can conduct inquiry under A. After conducting the inquiry, if he still wants to proceed, then he is required to issue a show cause notice to me, providing the information and the results of the inquiry. And then I will have to reply to it, and then he is required to pass the order, because then there will be no use of section 1 of the show cause notice. If I don't have the reason to what I will reply, and that is
Here it says the assessing officer shall, before issuing any notice under section 148A.
Yes.
Now 148A, earlier 148A is just a notice that you file your return.
148
One
is for show cause notice.
It's just a notice to file the return,
Yes.
nothing more.
Yes.
147, which was there, now has been amended, whereby it says that he will, after the what has been decided under 148A,
Yes.
he will, the power is being given to reassess.
Yes.
148A, earlier the 147 says that where the power to reassess was subject to the condition precedent of there being a reasons to believe.
Yes.
Now, these reasons to believe is no longer there in section 147 now.
Yes.
Now, 148A also does not say about any reasons to believe.
Yes.
The reason why it is not required because there is an inquiry being postulated under the provisions of that section.
Yes.
Now, what is required to be provided? Provide an opportunity of being heard to the assessee with the prior approval of the specified authority by serving upon him a notice to show cause within such time as may be specified in the notice, being not less than 7 days, but not exceeding 30 days from the date on which such notice is issued, or such time as may be extended to him on the basis of the application in this behalf, as to why a notice under section 148 should not be issued on the basis of information which suggests that income chargeable to tax have.
Yes.
Yeah. but it does not
I-
postulate that
Lordship,
there
may
is
practice.
a requirement of providing you that information.
So lordships can just read the last line also. In
Yeah.
as escaped assessment in the case of the relevant assessment year and results of inquiry conducted, if any, as per clause A. So that is why he has to issue a notice that I have received XYZ information. Basis that I believe that you
No,
are
he has already informed you that information in the notice
Yes.
under 150 148 AB.
So if that information itself is wrong, then the very basis of issuing notice is
But
the information.
would that be a subject matter of a writ petition?
Because then how I'm going to challenge this? Because he is proceeding, he is converting the allegation, everything
No,
is
how
doing.
can this court look into all
Yes,
these
lordship,
aspects of the matter?
I can show the
You see,
judgment.
kindly appreciate
Yes,
the matter which was there before the Supreme Court in that judgment was a case where the respondent authorities, income tax authority, have issued show cause notice, have issued process under 148
yes,
without resorting to 148A.
yes,
And under such circumstances, the Supreme Court held that you can't do it in view of the amendment brought in the year 2021.
yes,
However, balancing the equities, the Supreme Court exercised certain powers to that effect that if you are doing so, now this notice which has been issued under 148 would be now considered to be an information under 148A,
yes,
AB.
lordship.
So accordingly, directed certain things. But the
Yes.
issue before the Supreme Court was not that the information has to be given. Yes,
Yes.
what is given is the upon inquiry, what did you find out?
Yes. So
What are the information is nothing to be given out there.
lordship, information forms the basis of the conducting the. I request if lordships can come to the division bench judgment. It's
Where?
at page 26, para 12.
Yeah.
Page 26, para 12. From the reasons recorded by
This
the
is a judgment the way. Oh, this is under the old 147A.
Lordship, in the second volume, there are latest judgment of the Delhi High Court also, Honorable Delhi High Court, where they have discussed this 148 and 148 also. That
Understood, but how can you rely this judgment? How did it have any relevance?
in the second volume, under the new law there. In the second volume, I have put the judgment of the Delhi.
because this is a judgment pertaining to 1975.
Yes, I
when
request.
law was there at that point of time.
It's a Delhi High Court judgment at page 15.
Annexure?
5,
Page of the second volume.
second volume.
Yeah, what does it say?
These are under the new provisions.
Hmm.
Relevant part is at page 20, para 22.
Yes.
Having noticed the rival submissions, contentions which were addressed, we find that the notice under section 148AB of the Act undoubtedly suffers from certain fundamental factual errors, as was pointed out by the writ petitioner, and which fact has been tacitly admitted by the respondents. The SCN has proceeded on the premise that the petitioner had not filed its return of income for AY 16-17. Once this was established to be factually incorrect, the respondent, while passing the order under section 148 AD, sought to overcome this mistake by observing that although a return of income has been submitted, it had not been subjected to assessment as contemplated under section 143(3), 47 and 144 of the Act. It, while passing the order disposing of the objections taken by the writ petitioner, also observed that the income relating to the transactions in question had not been offered to tax. It is on the aforesaid basis alone that the AO proceeded to observe that income earned in the concerned AY appeared to have escaped assessment. We at the outset note that the aforesaid reasoning as adopted in is rendered wholly unsustainable, since undisputedly prior to the petitioner submitting its reply to the SCN, the AO was not only totally oblivious of a return having been submitted, it had not even examined the same in order to form an
So
opinion.
then this is not relevant. This is not relevant.
The lordships come to para 24. They have had this.
Yes.
Yes. We then find that the question of whether the petitioner would be entitled to the benefit of DTA was one which can be alluded to only in the order framed under section 148 AD of the Act. Suffice it to note that the original notice under 148 AB was not even founded on the allegation that the petitioner was not entitled to claim the benefit of that article. it was only in the course of framing of the final order 148 AD that the respondent ultimately sought to draw
This is again on a different point, but where is the question of giving you the information?
Lordship, if I have to reply to a show cause notice, at least the allegations, I should know what are the allegations. He
That
is
is,
saying,
the allegation is there, which is coming out from the inquiry.
so Lordship, in the show cause notice, he is saying that allegation is that I made a bogus purchase and I am supposed to file a reply to that. So that allegation is wrong. So I never
You,
had the opportunity.
you have to supply the remand. Did you ask for that? What is the information?
I replied to it. So that is
You
what he
said that no, it is not true.
So
Your reply is it is no, it is not true. Kindly see your facts
Yes.
out here.
yes.
See, the judgments are to be decided on the basis of the facts. Kindly see the notice, page 50.
Yes, Lordship.
Whereas I have information which suggests that the income chargeable to tax for the
Yes.
assessor has escaped assessment within the meaning of so and so. The details of the information and inquiry, if conducted, are enclosed with this notice as annexure A.
He is providing me
Yeah.
the information. and inquiry.
Wait. Now, kindly see the information. Information has been received through so and so. That so and so had made bogus purchases from swastik traders. So and so Iman. A search and seizure operation under so and so was conducted in the residence of Abhishek Mittal and so and so. Consequent to the execution of the warrant, the assessee filed return under 153A disclosing 1 lakh so and so, and the income of the assessee was assessed here. During the course of the assessment, it is seen that the AO has examined the books of accounts along with the bank statement and other submissions along with the seized and impounded documents. It is also seen that the assessee has offered additional business income of rupees 97 lakhs in its computation. However, there is no evidence on record that the purchase from swastik traders, so and so, for demand during the has been examined. Considering the facts and circumstances, it appears that the income chargeable of taxes of so and so have escaped assessment. In view of that, you are required to show cause as to why your income should not be reassessed under 147A, so and so, and notice under so and so should not be issued for a year which is suggesting the income chargeable to taxes so and so. So this is what is being given. So you have
Yes.
been given due information to that
So-
effect.
So that information is wrong. And Lordships can have that 148A says that he
No,
has
no,
to
let us see what is your basis of your information is wrong. Kindly
Yes.
see what from para 1 of the annexure, it is noted that your honor has received information that inside a bogus made by so and so amounting to so and so. Your information is partially correct.
So figure is correct.
I have made the sales of similar amount to the said firm and have made any purchase during 19 so and so from the said concern. And as such, there can be no reason that my income chargeable to tax had escaped. That's in support of the sales made by me. I'm enclosing here with the ledger of the said copy in so and so, a copy of a particular page of bank account in which I have received the payment, copy of the invoice received by me, and a copy of a particular stock. That's during the course of the search year, so and so, it has been so and so. Now, after this, the order was passed.
If I take in
This was
Lordship
the
some
order
minute.
which was passed.
Yes.
And it was found that accordingly a so cause notice was here, so and so, it is seen that the SI did not purchase the so and so, so and so, so and so. In that case, as we have seen, they are strong in here, the income charges of here. Now, this order was put set aside, so let us not go into that. Now, let us see the order pass or this as well. Objection to the notice.
Lordships can just have page 79. What reasons which the officer is giving for the mistake.
No. This is the first part of the order which have been set aside.
Lordships in the 79 is there. What he is giving the reason. That is in for page 79, fourth
What is
plus
relevant?
paragraph.
No, kindly come to page 78.
70,
The
yes, yes.
instant case is a proceeding that has been initiated under the new substituted provision AI in particular so and so, and the proceeding in which has been initiated as per explanation 1 of Iman being on the basis of information flagged in the case of an SSE for the relevant assessment year in accordance with the risk management strategy formulated by the board, which suggests that income chargeable of tax have escaped assessment. The information being case reported uploaded in the inside by so and so. What is relevant and important is the large micro picture of the interstate network racket of bogus purchase so and so with a motive to evade taxes. Coming to the flagged information on the SSC, it is in the examination of one of the perpetrators being so and so, examination under one so and so, in the statement recorded dated so and so, relevant extracts from the statements are scampering hereinafter in disorder. Say had confessed to have clandestinely arranging racket of providing a bogus accommodation, entries of fictitious, bogus, non-existent purchases of sale in the return of year and modus operandi. In the list of fictitious entries was the name of swastik traders. You are swastik traders.
No, I'm not. I have made a sale transaction to this
Huh?
entity. I have made a sale transaction to this entity.
You have made a fake
I
transaction.
have made a sale transaction.
Sale transaction. Okay. As the SSC's name surfaced from the list of parties with whom these fictitious entries has arranged bogus transaction, therefore the information has been uploaded in the insight and was ticked under the category bogus. Yeah. The information being squarely as per explanation Iman, thus letter was issued to the SSC under Iman providing opportunity. The SSC replied that it had made sales to the third party, namely Swastik Iman. The inside information was received in the month of Iman, which is very busy and hectic month, being the various views of the understand of the considering the seriousness of the information, order and the was passed. The agreed was agreed passed by Services.
So this is a justification Lordship is giving, and this information was never provided to me. This Ashok
What
Gupta and
information?
everything. This information which is referring to that inquiry was conducted to Ashok Gupta.
That is
This
already
state.
that information. That is
No,
information.
that is only that one paragraph
No,
is
no,
given.
that information is already there. In
No.
this letter, it is already there. You see, information has been received from the inside portal of RIA that so and so had made bogus purchases from swastik traders.
That is it. But
Yeah, so that information is already there.
he has done a statement of Mr. So I have never
No,
been
why
given an
the
opportunity.
statement? The statement, you see, how it happened is there was one person named Ashok Kumar
Yes.
Gupta, who made certain confessions. And
Yes.
he said that I made certain entries with this, I have made certain fictitious accommodation, bogus entries with various parties, including swastik traders.
Yes.
Now, these swastik traders was flagged. And upon being flagged, it was noticed that you have also done so. And as such, you have been thereupon it was found out. It is not Ashok Gupta who has said about you.
Yes.
Ashok Gupta has never referred to you.
Yes,
So
Lordship.
that is therefore not a material information to be provided to you. What is
Yes.
provided to you is that after Ashok Gupta made that confession, there were various parties of which one party was found as swastik traders. You had a trade dealing with them. And there on the basis of these trade dealing, they was found out there that there was a high risk. You made a bogus purchase here and as such you were asked. That
Yes.
is what you are being asked. Now, when you were asked, you said that no, there was no bogus. Yes, I have made transactions with swastik traders, but I have not made any bogus transaction with them. These are all these receipts which are there.
And Lordship, there's one more point to it. The allegation.
Mr. Jain, kindly appreciate. This is
Yes.
a 226 court.
Yes.
There is a limitation of going into certain factual aspects. Certain factual aspects, this court is not going to. Now, therefore, the question that the information was not provided to you, the basis of the information has been provided to you because they found on the basis of that. It is immaterial because Ashok Gupta never revealed your name. They only revealed the name of swastik. Then
Yes.
they made searches with swastik, found that these are the various parties, including you, who have made bogus transaction, and this was informed to you. So information has been provided. Now what happened? In the examination of 131 statement, the said Asoko had confessed an Iman increase of bogus so and so. Right. From the above deposition, it is amply clear that the racket was for accommodation of entries of bogus and Iman by was a case of transactions claiming sales to these parties. But the sale also had admitted that he and his accomplice provide also bogus sales for buyer. Interest, this issue needs to be looked further as per the reassessment records itself. In this case, the SSC there has been a search made and thereafter so and so SSC will return because the search and the after convicted state the same is about the purchase of order. Sir, I don't understand how you are bringing the joining this new era enterprise into the scene with the petitioners.
Page 90.
Page?
90.
Yes.
Interestingly, the issue needs to be looked further as per the assessment report itself. In the case of the SEC, there has been search and seizure action under section 132 mounted on 8/2/2019. Thereby, consequently, there had been search assessment proceeding initiated under 153A.
Total income at rupees because of the search and seizure actual finding is no, that is okay. But how are you interlinking the Naga?
Yes, Dr.
Yeah,
that is
with
also
this.
mentioned here in page 90, paragraph 2 and 3.
Yes.
Then the other connected steps prior to the sale is what about the purchase for the purported goods sold. From the detail of the purchase on a record submitted by the SEC, the purchase are shown to have been made from one NSCN enterprise provided John in check.
From the details of the purchase on record submitted by the SSC. So the SSC submitted these documents.
Yes, he submitted.
Huh?
This is not this.
These are the two documents which were submitted by the SSC, page 91 and 92.
Yes, sir.
Okay.
What's the finding is also there.
Are shown to have been made from one NCS. This is purchased by Swastik Traders.
And
Now-
also interestingly, what paragraph?
Huh?
Page 90.
Huh.
Thus, in the present issue here, the purchase as well as the sales are also doubtful. Furthermore, the purported goods are stated to be Rajma and Kabuli Chana. These pulses quite unknown in Nagaland, not known to be cultivated in Nagaland, and neither would there be a local demand for such non-local unknown pulses. The purported purchase is from NCS Enterprise Proprietor so and so, and the sale to the fictitious entries at Delhi. Basically and effectively, the goods are transacted at Delhi So the accounting entries are but near routine of the network record in the Excel state division of taxes. Furthermore, as per the stock statement, both the purchase and sales are on the same day. From the details of record, statement is attached.
But yeah, the SSC's business is by the style name National Commodity Supplier Enterprise.
Not so.
And John Incham's business style named NCS Enterprise.
Right.
Okay.
Yes.
But similar sound names and which can easily be mistaken one for the other. Thus, in the present issue here, the purchases as well as the sales are also doubtful. Now, kindly come to these, page 91 and 92. What are these documents? Yes, Mr. Jain, what are these documents?
Lordships, my entity is New Era. Just a minute, Lordship.
What are these two documents, 91 and 92?
91 is a challan, Lordship, where
This is a thing which has been sold.
stock item register of Kabli Chana.
Yes,
So, 1st of May to 31st May, 1st of May, Kabuli Chana and Rajma to Swastik traders. Then there is a mention of voucher name NCS Dal. And this is NCS Dal. Voucher name. Then, you see Swastik traders down below NCS Enterprise creditor. Then,
Lordships, my entity name is New Era Enterprises.
huh?
My entity name is New Era Enterprises.
No. Down below you see, what is this? Swastik traders.
So
Then
these
down
are
below
my
NCS
stock register.
Enterprise.
Yes, these
Who
are
is
my stock
Who is NCS Enterprise?
from whom I have purchased the Rajma for further selling it to the Swastik traders.
So you New Era purchased from NCS.
Yes,
Purchased.
yes,
And then you sold it to Swastik.
yes, yes, yes.
So
That's
you
it. I'm a
purchased
trader.
from them and then you sold it to Swastik.
Yes,
Then assesses business in the name of so and so. That's the but the purported goods are stated to be Rajma and Kabuli Chana. These purchases are quite unknown in Nagaland, not known to be cultivated in Nagaland, and neither would there be a local demand for such non-local unknown purchase. Purported purchase in the name from NCS Iman and the sale to the fictitious entities at Delhi. Basically and effectively, the goods are transacted at Delhi. So the amount accounting entries are but mere routing of the network record of the industry. Yes, how do you explain this penultimate paragraph of paragraph 90, page 90?
Page? Page 90.
Page 90, the penultimate paragraph. This is the basis,
Yes, this is
the crux.
Yes.
You say that the purported goods are stated to be Rajma and Kabuli Chana.
Yes.
These pulses are quite unknown in Nagaland. And non-local unknown purchase pulses. The purported purchase is from NCS Enterprise and the sale to the fictitious entities at Delhi, that is Swastik. Okay. Basically and effectively, the goods are transacted at Delhi. Okay. So the accounting entries are but mere routing of, So what they are doing is that as per you, the sale, purchase, everything happens in Delhi.
Yes.
But they are routing it on papers through this.
Interestingly, 91 and 92, the dates are same.
Huh?
Dates are same, 22nd May 2017.
Hmm.
Purchase and sale, the same.
Also, it may be observed that the SSC in his petition to the High Court has not made mention about the purchases, the party from whom purchased, and the odd nature of the goods so traded. What is relevant and important is the larger macro picture of the interstate network of bogus purchases, bogus sales, and IMA with motive to evade taxes. Thus, in this case, both the purchase and sales are definitely suspect, and there definitely would be incurring of a brokerage commission for arrangement of. Thus, this will therefore income charge. But with this decision, have you not already come to an opinion that it is income chargeable to tax? Because now what happens? 147 gives you the power to reopen the assessment. Okay? You open the reassessment. That means the moment you open the assessment or go ahead with the reopening the assessment, the earlier assessment order goes for 6. So now you are going to reopen. Now, earlier the safeguard of having reasons to believe and all these things, that has been done away with in 147. Now if the moment you have a decision under 148A, you can go for 147. And 148 notice is only for submission of return. So therefore, the earlier method by which coming to the court, challenging the writ jurisdiction, that has been done away with under this 148. Now, this court under 226 can look into what aspect?
In privacy, there is illegality, but here that is not there.
Well, to what extent? How far this court can go into? It can go into the case of where what is alleged is different from what order is being passed. Just for example, in Delhi, the case was that there was no assessment proceedings. Whereas there was an assessment proceeding, but however, that was not in confirmation with 137. And as such, it was held to be bad. Now, here we are trying to exercise the power of judicial review in respect to so far as the decision is being taken under 148A, and more particularly to and more particularly to 148AD.
Yes, sir.
What is the scope? I'm coming back in 10 minutes.
It's paragraph 15.
2014. I don't have it.
Yeah, that's just fine. If you see government here, paragraph has been put. Paragraph 28. Okay.
Yeah.
Paragraph. Thus, it can be said that this court has recognized some exception to the rule of alternative remedy where the statutory authorities has not acted in accordance with provision of the enactment question or in defiance of the fundamental principle of judicial specific or has resorted to go the provisions which are repealed or where an order has been passed in total violation of principle natural justice. All these things are not there in this case.
This is a matter pertaining to surface area.
Yes, I'm just relying on several of those.
Yeah, that is okay, but that is on a surface. I'm not on that. I'm only on the question is what is the scope of these are certain factual aspects.
Yes, that,
If these are factual aspects, should this court at all go into that aspect so far? Or should it only go into the question of that as to whether the mandate under 148A have been duly complied with?
yes, Lordship is to see whether
If the statutory mandate is being complied with,
there is no scope for.
what is the outcome? Yes, you have not, the reason on which you have issued a show cause
Clear.
and the reply which has been given, the petitioner have been handicapped because of non-furnishing of certain reasons or certain reasons which are non-existent, then obviously 226 can lie. But would it be proper on the part of this court to entertain this type of disputes?
My submission.
It would be only on the basis of these persons which are to be looked into by those authorities. Like if you see the Delhi High Court judgment, which Mr. Jain is referring to, is a case where the basis of issuance of the notice was on a non-existent aspect.
Non-existent. But here it is there. They have admitted that partially information is correct.
You see, the requirement why the inquiry report is to be furnished is very specific. But it does not say of providing that information because the information may be classified also.
That may
You cannot give the certain information. Somebody may have a classified, you may have a classified information. But on the basis of the information, what is the inquiry? Unless some documents are shown that it is on the face of it, it is perverse.
then
Then the question is different. Here is a case where you have stated that here there are certain bogus transactions from these persons concerned, made by a confession being made by some Ashok Gupta as regards Swastik Enterprise.
yes, that is
That is your information which is there, which is however not material. But because of Swastik Enterprise being one of the parties where you had made that confession, you made the further search and could find out that these SSCs were in some way connected.
connected. That is mistake.
And that is on the basis of those two receipts, which they also admit of issuing those two receipts.
They have admitted.
Their basic case is out here that look here, we have done genuine transactions which are not false. Now, whether it is genuine or not, isn't it for the authorities to look into?
Lordships,
Yeah,
may I
that
just,
is your
one more
judgment.
judgment, what Lordships have asked, may I just, Delhi High Court order, last judgment, that's a different judgment, Lords, the High Court has answered this question also. Second volume compilation, page 27. Page 27, para 4. In light of the aforesaid disclosure, the respondents, while framing an order under section 148AD, then sought to call upon the writ petitioner to explain the source on the basis of which the acquisition was made. Undisputedly, this issue was never constituted the backdrop for the formation of opinion under the issuance of a section 148AB notice. We note that we had in a recent judgment rendered in ATS infrastructure so-and-so examined this position and come to the following conclusion. We thus come to the conclusion that the enunciation with respect to the indelible connection between section 148AB and 148AD of the Act are clearly not impacted by explanation 3. As we read section 147 and 148 of the Act, we come to the conclusion that the subject of validity of initiation of reassessment would have to be independently evaluated and cannot be confused with the power that could ultimately be available in the hands of the AO and which could be invoked once an assessment has been validly reopened. So these two are different proceedings, Lordships.
Mr. Jain, bad luck. Unless this court feels yes, some case, but from these materials, I don't find it. Other case same?
Yes.
Yes, same Lordship.
Tempo.
It's only the order date will change, rest everything is.
Yes, who is there? Item number 4. Oh,
So that's
What
a
is
service
this?
tax matter, lordships.
huh?
That's a service tax matter, lordships.
Okay. What is this?
Lordship, this challenges the impugned order. There are two grounds this challenge has been made, that this is wholly without jurisdiction and there is a violation of principles of natural justice.
Why?
Lordships, I am a resident of Arunachal Pradesh. I fall within the jurisdiction of the Itanagar Commissioner. Itanagar Commissioner has already examined me for a particular transaction, the very same transaction which is under dispute here. My jurisdiction commissioner has already examined that, and I fall within the jurisdiction of Itanagar. I have nothing to do with the Assam state. Dibrugarh Commissioner, basis some data received from income tax, has issued a show cause notice to me that was never served on to me. This is a violation of natural justice that the notice has never been shared to me. I have received the order in my email copy, which again is not a valid mode of service. There's a personal hearing notice that was also sent to my email that again is not a valid mode of service. But first and foremost, this notice, I don't fall within his jurisdiction. This 1.5 years I have filed the petition. He has not even made an inquiry with
Raise
the.
that. Did
So,
you raise that
Lordships,
issue?
Lordships,
Did you raise that issue?
I was never served with the copy of show cause notice. They have never physically served copy to me, or not, nor in the email also they have never served.
Huh?
They have never served. In fact, the very basis of their information, which they say Form 26 is, also has an address of Arunachal Pradesh. So I don't know from where the Dibrugarh Commissioner has exercised the jurisdiction. Page 51, Lordships, is the Form
What is
26.
this Annexure 7?
Annexure 7, Lordships, is the PH notice. This one PH notice I was served on the email, but email is not the valid mode of service and I am not supposed to look into my email. That also I
How
will
did
show.
you get this?
On the email it came.
Then?
So on the email it came, Lordships, it ignored my attention. We to admit, but email is not the mode of service prescribed under law also. So I'm not supposed to look into email. Section 37 of the Central Excise Act clearly lays down how the order has to be served or any notice has to be served on an assessee. It was never served on to me. And there's a Supreme Court judgment also which says that if a thing has to be done in a particular manner, it has to be done in the earlier if service was prescribed
No,
only.
does the Supreme Court say
Yes,
that as regard after 2017,
yes.
there's a requirement of issuance of personal hearing notice only by post?
Every notice has to be by post only, Lordships. There's a section,
Where?
section 37 of excise. My compilation has it.
Of?
A Central
Where is
Excise Act.
compilation business? No compilation.
Compilation is clear. Well,
Where is the compilation? And what are you challenging?
impugned order, Lordships.
Is 71.
Yes. Tell me.
Page 26, Lordships, section 37C.
Yes. 37.
Service of 37C.
Any
Service of
decision or
decisions.
order passed or any summons or notice issued under the Act of the Rules made therein under shall be served by tendering the decision, order or so and so by registered post with acknowledgement due or by speed post with the proof of so and so to whom. If the decision or order can be served on the manner in affixing, if the decision of a be served in the manner, every decision or order. Now this is under the Central Excise Act
Yes, Lordships.
1944.
Yes. This has been made applicable to service tax also, Lordships, by section 83A. That is at page 14. Page 14, section 83. Section page 14, application of certain provisions of Act 1 of 1944. The provisions of following sections of Central Excise Act 1944 as in force from time to time shall apply so far as may be in relation to service tax as they apply in relation to duty of excise. So in the last line, 37C is also mentioned, Lordships.
This is the central excise. Finance Act due or the service
Finance
tax
Act
due?
1994 is the service tax, and then the
Ah.
Central Excise Act is 1944.
Now that I know. This is the due for what? Service tax.
Service tax, 19. Lordship may have page 62. That was the notice which was issued by my jurisdictional officer, Commissioner to me. The pre-SCN.
Hmm?
Page 62.
Yes.
It has come to notice, Lordship, it has come to notice that you have provided service to various recipients and received payment of rupees so and so as evidence from Form 26 received from the Income Tax Department. Lordships have the amount. This is important because in the impugned order, this is by Itanagar division. And now I take Lordships to the impugned order.
Mr. Jain, you can't refer only one line.
Yes,
I don't read the files.
Lordship may have, because others is only the complaints. My lords, I can read the entire, no problem.
Huh?
I can read the entire issue, no problem. I can read the entire.
No, your case is twofold. One is
Yes.
on the principles of natural justice, and on
Yes.
the other ground, it is a jurisdictional error.
Yes, Lordships, yes.
The principles of natural justice is on the ground that you have received the notice by email, but that is not in terms with section 37C.
Lordships, show cause notice I didn't receive even by email also. I received only the
You have
personal
not
hearing
received
notice.
the show cause notice.
I received only the personal hearing notice.
Where is the show cause notice?
There is no show cause notice because I don't have the copy till date.
And when did you receive the pre-notice consultation?
Pre-notice is by my jurisdiction commissioner.
Okay, then
By
as
Itanagar.
regards this one by provision
By
of
the
the
Dibrugarh,
posting.
Dibrugarh
Who has
commissioner.
done this?
Dibrugarh commissioner.
Annexure 6 is by whom?
Annexure 6, Lordship, is by the Dibrugarh commissioner.
Huh?
And Dibrugarh commissioner, 3, 4 and 5 are by Itanagar commissioner.
Annexure 6.
6 is by Dibrugarh commissioner. The
Where?
present respondent 2.
Where it is Dibrugarh?
His junior officer has given. It is mentioned, Lordships, Government of India, Office of Superintendent, Central Superintendent, Lakhimpur. So he falls within the jurisdiction of Dibrugarh Commission.
So he has issued this.
Yes, these are the inquiry letters.
Did you receive this?
These 2 letters I received through email. Again through email, nothing by hard copy post. Then he
what
has
did
issued
you
a.
do? What did you do? You
I
did
didn't
not
reply because I never checked that, Lordships.
Till that you have neither submitted your reply to the demand come show cause notice nor attended the personal virtual hearing on so and so. However, following the principles of again, we are fixing another date. Yes, what is your case?
Lordship may come to page 72.
Yes.
Paragraph 1. A demand comes suppose notice dated 2010-2021 was issued to the Principal Commissioner GST Dibrugarh to Sri Abram K. Kechi petitioner bearing PAN number so and so having their premises at Hilamara, North Lakhimpur. Then Lordship, page 74, paragraph 1.7.
Now he says that he has received it by email. You sent it by email.
Lordship,
It is he who is saying.
Page 76, paragraph 1.5. Page 76. Was
Yeah.
sent through post. 1 point.
Return undelivered from the address of the noticee with the remark addressee left, return to the, as the answer was returned undelivered by so and so here, was requested to cause delivery of the same to her. A copy of the was pasted in the notice board of the divisional office as well as of the headquarters at Dibrugarh.
In 1.16, 1.17 also.
So then it will be in compliance with 37C, 1C. Okay. So if this is being complied with, then he says that you have sent it by email.
Lordship, in order said that it was sent through registered post.
Huh?
It was sent through registered post.
No, but Lordship, they should send to my address. This is not my address where they've sent it. The information which they are referring to itself as an Arunachal Pradesh address.
37 1C is also there.
No, but it has to send to my address. They have sent to
37
some
1C is there, na?
37 1C is there, but it has to be sent through post. I agree. But post has to be sent to my address. I am in Arunachal Pradesh. They should have sent it to Arunachal Pradesh. I am not a resident of Lakhimpur. From where they have got this address, I don't know. The form 26A which they are referring to itself has an Arunachal Pradesh address. Lordships can come to page 51. My GST registration has an address of Arunachal Pradesh. Form page 51, Lordships, form 26A. It has my name. My form 26A, Abraham Kaya Teki, Papum Pare, Arunachal Pradesh. They should have sent to this address. My GST registration, that again is at page 55. It has an Arunachal Pradesh address. My jurisdiction commissioner has already examined me.
When did you receive this? 2610,
26 and Lordship.
11/8.
20, 70. Lordship, this just. Lordship, that I will have to check because that date I don't have exactly where I received. That date I don't have, Lordship, so that I will have to check when the email was received.
Then
It was received somewhere in 22, 23, it was received, Lordships, in somewhere around January. That's what my understanding is. But exact date, Lordship, is not there.
now your address, your address and the 26AS address are different?
It's the same address, Arunachal Pradesh.
No. Mr. Jain,
Yes, Lordship.
see page 51 and page 50.
Yes. Page 50. Teki building, Papum. These are Arunachal Pradesh, Papum, Pare. Maybe, Lordships, exactly I don't know that date may be my residence, that may be my office building.
Your registration,
Yes.
your registration and made under the this act, whatever
Yes.
GST.
GST is at page.
GST is different from what is there in the 26AS.
Yes, Lordship.
It is different
Yes.
because one is at 791110
Yes.
and the other
Yes.
is 791109.
Yes. 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 Yes, Lordship.
One is model village, the other is different.
Yes.
So where should the address be sent?
Lordship, if they can prove in either address, it may have been subsequently changed. That I will have to check.
Huh?
But Lakhimpur is nowhere my address. It may have changed subsequently. That I will have to check, Lordships.
Yes, what is this? Why are you selling it to Lakhimpur?
Okay, because it is his business premises there.
Huh?
It is written in paragraph 1 of page 72. Again, I'm reading the principal.
That is your order.
Having their premises at 1 Ghilamara, North Lakhimpur,
Where?
page 72, first paragraph. A demand comes so-called notice dated so and so, issued by the principal commissioner, CGST Dibrugad.
Empty enterprise. Empty enterprise is what?
Is my proprietary firm.
Having
Huh?
their
Is my proprietary firm.
Empty enterprise. It's a proprietorship firm.
Yes, Lordships.
And what is the address of the empty enterprise?
That Lordship GST registration has it. 55, page 55.
This is the address.
Yes,
Yes,
page
sir.
55, legal and trade name, empty
And-
enterprises. It is
and
mentioned.
empty enterprise, this is there. So, CGST. Enterprise. What is your basis? PAN number. PAN number is where?
PIN number is page 72.
PAN number is AIYP.
2833L. Having their premises at
Kindly see his PAN number in 26 AS. The address of the SSA is shown as this. From where have you got this address? Premises at Zila Pukuri so and so.
North Lakhimpur. Page 80, Lordship,
Page 80.
page 80 of the impugn order.
Ah,
You can see for by speed post
ah.
and address is 19 Enterprise on Ghilamara, North Lakhimpur.
Okay, you have put all these things, it's okay. But the fact that this is not his address, from where have you got this address?
If I can produce the original records and
Huh?
can also got information from the.
Why won't you file your affidavit? We'll consider that without filing an affidavit, we'll set aside this.
I have also made Lordship. On
We'll
the
set aside this.
Lordship,
No affidavit filed in spite of various of things.
or I can produce the original record. Lordship. The affidavit may not be required, but in the present facts and survey of the case.
Huh?
See, my,
Not necessary. We allow this repetition. I've been given so much of opportunity, why won't you file it?
no, Lordship,
We impose cost upon you.
my submission may be recorded.
GST is very big,
No,
10 lakhs should be good.
Lordship, affidavit may not be required in the present facts. and
Why not? This is the most pertinent thing. He has asked you on two aspects. First, where is the question of your jurisdiction?
Lordship, because his office located in the state of Assam,
Where?
Lakhimpur,
No, his office, but does he have a PAN number there?
is there.
You are referring to a PAN number, which PAN number 26 AS refers to an address out there in Itanagar. There is a GST registration that they have already been inspected, looked into by the this person concerned. What is his name? Your
Abraham Pan-
this
Abraham Teki.
Office of the Commissioner CGST, Naharlagun. Why you are not taking into account with them?
Lordship, thereafter,
Every person comes up and does everything. Means everywhere. Tomorrow you get it done from Jaipur.
no, Lordship, page 68.
Huh?
Currently, page 68.
Page?
Page 68,
Yes, where?
section 6. Address is
Go
written.
again, something.
Yes.
Then here all the documents were.
Understood. He has not received this.
But what's it then how he is received the.
He has got an email, isn't it?
Yes, through email I have received.
He has got an email. An email is not the procedure.
No, Lordship has seen the impin order at paragraph 1.15. Propose not to sit through registered post
Where?
to his address at Lakhimpur.
Therefore, the address is not there. This itself is here.
Address is
Return
left.
to the senders.
Address is left.
So,
Right, return to the.
that is the postal. But nobody was found in that address.
Yes, they have left.
Then-
His
Now,
address-
why did you put the address there? Show me a single piece of document which will show that this address is there. You have not.
It's annexed 6 onward. That constantly the same address has been written by the.
So what? You have not shown anything to that effect. The notice was issued as far back as on 13/3/2023. You have not done anything.
But on the face of the record, Lordship, the document says. that
The
is-
document says that you earn. Mr. Jain, you have an interim order.
Yes,
No, there was no interim order, Lordship, but
No
the
interim
depart,
order.
no interim order was there, but
This is the case for
Instruction.
setting aside immediately. For not filing your affidavit. Chalo, let us set aside this. Or Mr. A. Jain, A.K. Jain.
agent, AK Jain.
The learned counsel appearing on behalf of the petitioner. Mr. S.C. Kayal appears on behalf of the respondent. Numbers 1 and 2. The petitioner herein have assailed the order dated 25/11/2022 passed by the principal respondent number 2 primarily on 2 grounds. First, that the impugned order suffers from is in violation to the principles of natural justice, inasmuch as prior to passing of the said impugned order, the petitioner was not issued the show cause notice. The second ground which have been taken is that the petitioner is that the respondent number 2 does not have the jurisdiction in view of the fact that the petitioner has neither his office or any registration within the commissionerate of Dibrugarh. For appreciating the said submissions, this court finds it relevant to take note of the brief facts leading to the passing of the impugned order dated 25/11/2022. The petitioner herein is the proprietor of a firm in the name and style of MT Enterprise. Which is registered under the GST, under the Central GST, CGST Act 2017. And the principal place of business is Techi Building, Model Village, Naharagun, Papunpare, Arunachal Pradesh, 791110. The petitioner have also been allotted a GST number being 12 capital A, capital I, YPP 2833 L1ZM. As per the said registration certificate, the petitioner proprietorship firm does not have any additional place of business in the state. It is also seen from Annexure 1 to the writ petition that MT Enterprise does not have any other branch office, place of business in the state. Petitioner's proprietorship firm, MT Enterprise, does not have. It is also seen from Annexure 1 that the petitioner, which is the Form 26 AS, that the petitioner PAN number is AYA capital A I Y P E 2833L. And the address mentioned therein is E-1 Pang P-A-N-G, Sagoli C-A-G-A-S-A-G-A-L-E-E, Papunpare district, Sagoli, Arunachal Pradesh 791112. The records further show that the petitioner's jurisdictional office and the petitioner's registration, the petitioner's firm's registration the jurisdictional office under the CGST Act 2017 in respect to the petitioner and his firm is the Office of the Commissioner, CGST and CX Itanagar, Sector Capital A, Naharlagun 791110. In the backdrop of the above, it is relevant to take note of that on the basis of that on 30/7/2021, a communication was issued to the petitioner in the address, namely number 1, Ghilamara, Lakhimpur 787053 by the Superintendent of Central Goods and Service Tax, North Lakhimpur Range. Similar notice was also issued to the petitioner on 11/8/2021 by the Superintendent, CGST, North Lakhimpur Range. Subsequent thereto, the Superintendent bracket ADJ, bracket close. Central Goods and Service Tax at having its office at Milonnagar Lane F, Dibrugarh, have issued a notice to the petitioner at petitioner by incorporating the address at number 1 Gilamara, North Lakhimpur 787053. Pursuant thereto, on 25/11/2022, the respondent number 2 passed the impugned order. It is further relevant to take note of from a perusal of the impugned order that the PAN number which was mentioned was AIYP T2833L, and it was stated that the petitioner has an office premises at number 1 Gilamara, North Lakhimpur. It is also seen from para 1.15 of the impugned order that a so-called notice was returned undelivered from the address of the noticee, that is the petitioner, with the remark addressee left returned to the sender. And under such circumstances, the so-called notice was pasted in the notice board of the divisional office as well as the notice board of the headquarters office at Dibrugarh. It is further seen that taking into account that the notice was issued, taking into account that purportedly notice was issued, and the petitioner did not avail any remedy, the opportunity of personal hearing, the impugned order dated 25/11/2022 was passed. In the backdrop of the above, this court have heard the learned counsels appearing on behalf of the parties. Mr. A.K. Jain, the learned counsel appearing on behalf of the parties, submitted that there is no materials on record to show that the petitioner has any office at Gilapakuri, at number 1 Gilamara, North Lakhimpur. The petitioner's address is only at Nahalagun, Papunpare, and the jurisdictional commissionerate under the CGST Act 2017 is the commissioner of CGST, Nahalagun. He further submitted that even the 26 AS form, which was the basis for passing the impugned order, also showed that the petitioner's address is at Nahalagun and not at North Lakhimpur. The learned counsel further submitted that in the instant case, as would be seen from the impugned order, the show cause notice was issued at the address. The purported show cause notice, as stated in the impugned order, was issued at the address where an address. However, the same could not be served admittedly. And as such, they had pasted the said show cause notice in the notice board of the respondent number 2. The learned counsel therefore referred to section 37C of the Central Excise Act 1944, capital C, and submitted that when a order, notice, summons, etc. are to be issued under the said Act of 1944, the same can be done so only by sending it by registered post with acknowledgement due, or by speed post with proof of delivery, or by courier approved by the Central Board of Excise and Customs, constituted under the Central Board of Revenue Act 1963, to the person to whom it is intended or his authorized agent, if any. In addition to that, order, summons or notice can be served in the manner provided in addition to that, the learned counsel submitted that it is the learned counsel for the petitioner further submitted that in the case the service could not be meted out in terms with section 37C bracket 1 small a, then in that circumstances, subclause B and subclause C can be resorted to. The learned counsel further submitted that the instant writ petition was filed in the year 2023 and notice was issued as far back as on 11/13/2023. Until date, the respondent authorities have not placed any material also to show that the petitioner has any office at number 1 Gilamara, not Lokhimpur, wherein the show cause notice was sought to be served. The learned counsel therefore submitted, the learned counsel further submitted that this is a case coming within the ambit of the Finance Act 1994. And by virtue of section 83 of the Finance Act 1994, section 37C have been made applicable. On the basis thereof, the learned counsel therefore submitted that as there was no service of due notice to the petitioner in the address in which the petitioner carries on its business or has its registration, then under such circumstances, the impugned order being passed without a show cause notice is liable to be interfered with. The learned counsel for a petitioner further submitted that these documents which have been enclosed as annexure six and seven are documents which were sent by email and which the petitioner later on came to learn. He, however, submitted that as the mode have been duly prescribed under Section 37, Capital C of the Act of 1944, which have been duly incorporated to the Finance Act 1994 by virtue of Section 83. The service by way of email is totally not conceived. The legal counsel for the petitioner further submitted that it is only the Commissioner of CGST, Naharlagun, Itanagar, na?
Yes. Yes.
Itanagar,
Page 62.
Naharlagun,
Page 62.
Naharlagun, Sector A,
Itanagar Division.
Itanagar Division, who
Page
have
62.
the jurisdiction over the petitioner, and not the Commissioner of GST, or not the respondent number 2, under whom there is no the petitioner, under whom the petitioner does not carry out any has only the jurisdiction. He therefore submitted that the entire proceedings so initiated and the impugn order so passed not only is in violation of the principles of natural justice, but also is without jurisdiction in as much as an authority has passed an order who has no jurisdiction as per law. Yes, Mr. We'll continue at 2. You just find out on the question of jurisdiction aspect. Come back. Can you means now in this case, I'll keep that question open. But this I'm setting aside because there's no office, nothing in there. So there's no show cause I'm setting aside. But can you exercise the jurisdiction being any other office if they find out? Then you can issue a show cause notice in the proper address.
It is transferred to the other commissioner.
Just have a look.
Yes.
Territorial jurisdiction and naturally. No. Yes. Thank you. On the other hand, Mr. Esikal, the learned counsel appearing on behalf of the petitioner, respondents, submitted that the petitioner was granted various opportunities, but the petitioner did not avail such opportunities. Good stop. And it is under such circumstances that the impugn order was passed. He further submitted that the petitioner had an alternative remedy. It is already there. Your submission.
Just open instruction. Yes, he was also operating from Lakhimpur, Ghilamara address.
But where is the address?
No, that's why the proceeding initiated by the Itanagar Commissioner was closed.
Huh?
The proceeding initiated by Itanagar Commissioner was closed and this proceeding was taken.
Proceeding initiated by AIA was closed.
Yes.
But where is it?
No documentation index. It was, I've just talked to the Commissioner.
That's why.
But how did the Dibrugarh get the jurisdiction?
Was mechanic, he was running a business from Gilamara also.
Hmm?
From Gilamara also, he was operating it on premises.
But there is no premises anywhere soon.
That why that is reflected in the paragraph 1 of the agreement.
If it is submitted that as per his verbal instructions, the petitioner was also carrying on certain business on the basis of from Gilamara, not Lokhimpur. And as such, notice was issued to the petitioner in the said address. In addition to that, the learned counsel submitted that the proceedings which were initiated by the Commissioner of Central Excise of the CGST, Itanagar, was closed in view of the proceedings being initiated by the Commissioner of the CGST Dibrugarh. In addition to that, the learned counsel also referred to, submitted that the petitioner has an alternative and efficacious remedy to challenge the said order before the Customs and Excise Service Tax Appellate Tribunal, as have been duly mentioned in the order dated, impugned order dated 25/11/2022. First, upon hearing the learned counsels appearing on behalf of the parties, three questions arise for determination. First, number one, whether this court should exercise the jurisdiction under Article 226 of the Constitution, taking into account that the petitioner has an alternative and efficacious remedy in the form of filing an appeal before the Custom, Excise and Service Tax Appellate Tribunal. Number two, whether the impugned order dated 25/12/2022 is violative of is bad in law on account of non-service of show cause notice and an opportunity of hearing being provided to the petitioner. Number three, whether the respondent number two had the territorial jurisdiction to adjudicate the subject matter, taking into account that the petitioner does not have any office, place of business within the jurisdiction of the respondent number two. First, for deciding the first question, this court finds it very pertinent to take note of the judgment of the Supreme Court in the case of Internet নাই নেকি অ? Godrej Sarali Limited versus Excise and Taxation Officer come Assessing Authority and others, reported in 2023, bracket close, 109 ZSTR 402. The Supreme Court, in the said judgment, upon making reference to the judgment in the case of Whirlpool Corporation versus Register of Trademarks Mumbai, reported in 1998 8 SCC 1, observed that there are certain exceptions when the writ court would be justified in entertaining a writ petition despite the party approaching it not having the alternative remedy provided in the statute. The said exceptions were, number one, where the writ petition seeks enforcement of any fundamental rights, semicolon. Number two, where there is a violation of the principles of natural justice. Number three, where the order or the proceedings are wholly without jurisdiction, semicolon. Number four, where the virus of the act is challenged, or, semicolon, or where that where a pure question of law a pure question of law is raised or semicolon, number five, where a pure question of law requiring legal determination by the High Court is raised. In that view of the matter, the question therefore arises as to whether this court should exercise its jurisdiction under Article 2 to 6 of the Constitution. The answer to the same can be found on the examination of the question number 2 and 3. Inasmuch as question number 2 postulates relates to violation of the principles of natural justice, whereas question number 3 relates to exercise of jurisdiction without authority. In that view of the matter, this court defers its decision as regards the question number 1 for the time being and finds it relevant to take note of this question number 2. From the facts above narrated, there is no materials placed before this court by the respondents to show that the petitioner has any place of business at Ghilamara, not Lokhimpur. The CGST registration of the petitioner, which have been enclosed as Annexure 2, categorically shows that the petitioner's place of business is at Naharlagun, Papunpare, Arunachal Pradesh. Even the account number, permanent account number of the petitioner provided under the Income Tax Act 1961 also shows that the address of the petitioner is at Papunpare district in Arunachal Pradesh. This court have also perused the various notices which have been issued enclosed as Annexure 6 and 7. The addresses mentioned in those notices were at number 1 Ghilamara, not Lokhimpur. And the petitioner have stated on oath that the said address is not the address of the petitioner, which have not been denied by the respondent authorities. It has also been specifically stated in paragraph number 11 of the writ petition that these notices, which have been enclosed as Annexures 6 and 7, were sent through email. Which the petitioner did not notice. However, it is relevant to take note of Section 37C of the Act of 1944, which postulates the manner in which service of notice, order, service of decision, order, or summons, etc., are to be made. Section 37(6) C of the Act of 1944 is reproduced hereunder. Page 26 of the day. From a perusal of the above quoted section, it would be seen that any decision or order passed or any summons or notices issued under the Act of 1944 or the rules made therein under has to be served, shall be served in terms with subclause A by tendering the decision, order, summons or notice or sending it by registered post with acknowledgement due or by speed post with proof of delivery or by courier approved by the Central Board of Excise and Customs constituted under the Central Board of Revenue Act 1963 to the person for whom it is intended or his authorized agent, if any. There is no mention that such decision or order, such decision or order or summons or notices are to be served by way of email. Subclause B and subclause C will only come into action, can only be taken recourse to if the service of notice under subclause A cannot be effected. This court also finds it very relevant to take note of Section 83 of the Finance Act 1994, whereby the provisions of the Act of 1944, some of the provisions of the Act of 1944 have been adopted. And amongst the various provisions, it includes Section 37(c) of the Act of 1944. Under such circumstances, it is therefore seen that a service of notice ought to have been made by way of registered post with acknowledgement due or by speed post with proof of delivery or by courier or duly approved courier. The question, however, arises as to when such notice or order or summons can be deemed to have been effected. Now, the question therefore arises, however, arises that can it be said that subsection A of section subclause A of section 37(c), capital C1 of the Act of 1944 have been complied with if the decision, order, summons or notice had been sent in an address have been sent not to the proper address. The answer has to be in the negative. Under such circumstances, this court is of the opinion that the recourse to subclause C of clause 37C(1) of the Act of 1944 could not have been made if the decision order, if the notices were not sent at the proper address. More so, when the registration certificate of the petitioner categorically mentioned the address in view of the above, it would therefore be seen that the service of notice that the impugned order dated 25/11/2022 was passed without affording due opportunity to the petitioner. And thereupon, and as such, the same violates the principles of natural justice. The consequential effect of the said observations, said opinion of this court is that this court can invoke its jurisdiction under Article 2 to 6 of the Constitution, which is the question number 1 in the present facts. In the backdrop of the above, let this court take note of the third question so formulated. The third question pertains to who is the person, or as to whether the Office of the Commissioner, Central Goods and Service Tax, Dibrugarh Division, would have the jurisdiction over the petitioner, taking into account that the petitioner is registered under the Commissionerate of CGST, Itanagar Division. This court at this stage finds it relevant to take note of the submission of Mr. S.C. Kayal, who made a submission on basis of verbal instructions to the effect that the petitioner also carries on the business at Gilamara 1, at 1 Gilamara, not Lokhimpur, which falls within the jurisdiction of the Commissionerate of GST, Dibrugarh Division. The said submission, however, is not based on any documents being placed before this court or on the basis of any affidavit. At this stage, this court, however, finds it pertinent to observe, pertaining to reiterate that the respondent authorities were given due chance to file the affidavit, which they failed to do so, in spite of numerous opportunities. Now, Mr. Jain, where does the jurisdiction lies under what provision?
It, Lordships, if my compilation is there and there I have placed the notification which lays down the jurisdiction. Page
27,
compilation,
page
page 30,
27.
page 27, the relevant is 30. Serial
Huh?
number 30, page number 30. In the table, serial number 32. For Dibrugarh, the jurisdiction is laid down. And for serial number 47, Itanagar, the
No, no,
jurisdiction
no.
is laid down.
Is it on the basis of how the jurisdiction is conferred? Is it
Jurisdiction
on the
is
basis of
through
registration or is it on the basis of what you are doing?
where the petition stays. So the wherever my jurisdiction is, where I am located or where my registration is. Because it's a pan India.
Where is it mentioned? That where your registration is?
Lordships, in the service tax rules at serial number 2 of my compilation, serial number 3, rule number 3, appointment of officers.
Huh?
Page 16, page 16 of the compilation, rule number 3, appointment of officers at the bottom.
May appoint such central exercise as it thinks fit for exercising the jurisdiction here within such local limit as it may assign to them and also specify the tax available. No. How do you say that is it only on the basis of the registration?
So serial number 4 lays down, Lordships, that where I have to apply for the registration.
No, that
So-
is a different thing.
Yes,
You may, just for example, you may apply for your registration in Guwahati.
yes,
In that one. You
yes,
may have it. But you, at the end of the day, you are also doing some work in Delhi.
yes.
Then are you saying that the Delhi Commissionerate would have no jurisdiction? to
No,
issue?
no, Lordships, because I have a registration. If so, the service tax has the pan India registration. I can obtain for a centralized registration, and I can obtain for a area wise registration. Both are there. So if I have obtained a centralized registration, then it is only the jurisdiction where I have obtained registration that commissioner can only exercise. So even if I am having a centralized registration, suppose in Arunachal Pradesh, and I may provide service in Jammu, Kashmir, Rajasthan, anywhere, it is only the jurisdiction of Itanagar Commissioner who can issue notice to me.
How do you say so?
Because the centralized registration provisions, it is there, Lordships. There's a judgment I have enclosed. Sorry, just- in this. So Lordships have centralized at page 24, which defines who will be a centralized excise officer.
Where?
Page 24,
Hmm.
2 definitions, B part. Who will be a centralized central excise officer? Means the principal chief commissioner of central excise officer, chief commissioner of central excise, principal commissioner of central excise, commissioner of central excise, commissioner so and so, or any other officer of the central excise or any other person, including an officer of the state invested by the Central Board of Excise and Custom constituted under the Act, under the Central Board of Revenue, with any of the powers of a centralized officer under this Act. Within this, they have issued a notification. That, Lordship, is at page 27.
Hmm?
Then they have issued a notification. This is at page 27, appointing as a centralized excise officer.
This is for central excise.
So this is for service tax rules both, because service tax borrows the centralized excise officer from the excise act only. The lordships can say it is a mention of service tax rules also.
No. How are you saying that it will be based upon the centralized officer only? Means it has to only based on the registration.
So lordships in this notification, last
This
last
is rather
three lines,
very important.
it
point.
says the within
What are
the,
you showing?
Or two,
Four,
rule for two.
yes,
where a person liable to paying shelter on a service taxable provides such service from more than one premises or offices or receives such services in more than one premises or office and is having more than one player which is engaged in so and so and has centralized billing system or centralized accounting in respect of such service and such centralized so and so are located in one, he may at the option register such premises or area from the centralized demand and demand. The registration shall be granted by the Commissioner of Central Excise in whose within the premises from where the controller, provided that nothing contained in demand shall have to affect the registration granted in the premises or centralized unit. Where an FSC is providing a taxable service from more than one premises and does not have any centralized billing system or demand, whether he shall make separate application for registration in respect of each such premises here. Now you have a centralized. Yours is a
lordships,
centralized.
I didn't have any registration in service tax because services provided me by are exempt.
Huh?
Services provided me were exempt under the Service Tax Act, so I didn't took any registration. So as long as I'm providing exempt services, I'm not required to take any registration.
It is exempted.
Yes. And that is the reason when the Itanagar
So you don't
Commissioner,
have a registration.
no, I didn't have.
So if you
Under
don't
service
have a
tax,
registration,
I didn't, sir, under service tax, I didn't have, under GST, I had.
GST you have it, but you don't
Yes.
have a service tax registration.
No, lordships.
So how do you refer to 4.2 then? It has no relevance.
So even if where I am territorially located, only that person can issue, because if I'm,
So the GST registration has no relevance then.
GST registration is relevant only to show my address.
So only for your address. Otherwise,
Yes,
therefore anybody can issue notice wherever they have an office. You have a file your reply. We'll put it at your address now. You'll issue notice.
no, so lordships in that, just,
No. You
yes,
don't have a registration, matter is over then. The question is, just for example, you don't have a registration and you say that you are exempt. So
yes.
you should notice from there, they find out there. Do you reply to that?
That is what I've already enclosed lordships in my writ petition. My jurisdiction commissioner has issued a notice to me. That I've enclosed in my writ.
No, how can he have how can he have, if you have not registered, why can't anybody else do it? You don't have a centralized registration. You don't have at all a registration.
Yes,
If you don't have at all a registration, where is the question arises? Where were issues?
lordships,
You see,
in that
if you
case,
see Rule 4,
yes,
it's a rule, na?
yes,
Rule 4.2 says that if you want to have a centralized area, you can have it.
yes,
Then in that case, it will be centralized.
yes,
But if you want, and each, by way of a centralized registration, you can have it for all premises all over India.
yes, yes,
But if it is a case where you may also require a registration if you don't get your centralized registration in respect of all your premises. Here is a case you don't have a registration.
So lordships,
So anybody can issue. From
So
Bombay also.
they can issue if I have an office in their jurisdiction.
Where?
So if I had an office in Assam,
No.
they can issue.
Because their specific thing is that you have been working out there in Gilamara.
So that they should produce something on record, which they
That
have
is
not done.
not for here. This court is not going to decide that point. I'm giving them the year. They will issue a notice to you. You reply. Okay, clear. The third question for adjudication pertains to as to whether the respondent, number 2, had the jurisdiction, territorial jurisdiction to initiate action and pass the impugned order. Mr. A.K. Jain, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner is exempt from payment of service tax. And as such, the petitioner does not have registration under the does not have service tax registration. This court also takes note of section rule 4.2 of the service tax rules 1994. Four two and 4.3 of the service tax rules 1994. Which pertains to which stipulates that when a person is liable for paying service tax on a taxable service and provides such service from more than one premises or offices, or receives such service in more than one premises or office, or is having more than one premises or offices which are engaged in relation to such services in any other manner, making such person liable for paying of service tax. Such person can opt for a centralized billing system or a centralized accounting system in respect to such service, or he shall make separate application for registration in respect of each of such premises or offices to the jurisdictional superintendent of central excise. From the facts narrated, it is clear that the petitioner does not have any registration under the Finance Act 1994. The registration under the service tax. Does not have registration in terms of the service tax rules 1994. The address was shown in the writ petition pertains to the address as appearing in the Form 26 AS in relation to the PAN number of the petitioner. As well as the CGST registration, wherein in both places it has been shown that it is in Papun, in the district of, in Naharlagun, in the district of Papunpare, Arunachal Pradesh. Under such circumstances, a question of fact arises in view of the submission so made by Mr. S.C. Kayal that the petitioner also carries on its business at North Lakhimpur. And taking into account that the petitioner does not hold any registration under the Service Tax Rules 1994, this court is of the opinion that the respondent number 2, or for that matter, the office of the respondent number 2 has the territorial jurisdiction to issue the notice and to initiate the proceedings. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one. The impugned order dated 25/11/2022 is set aside and quashed on the ground that the same have been passed in violation of the principles of natural justice. The corrigendum which have been issued on 16/12/2022, which have also been put to challenge, is also and having been being based on the impugned order dated 25/11/2022, which have been set aside and quashed, is also set aside and quashed. Number two, the respondent, more particularly the respondent number two, would be at liberty to take appropriate steps, if so advised, against the petitioner. Number two, the setting aside and quashing of the impugned order dated 25/11/2022 and the corrigendum dated 16/12/2022, however, shall not preclude the respondent's authorities, more particularly the respondent number two, to initiate fresh action, fresh steps under the provisions of law, under the extant provisions of law. However, if such steps are taken, the petitioner should be issued a show cause notice in the address that is Teki Building, Model Village, Naharlagun, Papunpare, Arunachal Pradesh 7811110, which as per the petitioner is the present address of the petitioner. What about the limitation?
Case of spread it is 5 years.
Huh?
Case of 5 years. In case of listed pregnant section 73, it is up to 5 years.
5 years, it's time, within time.
Lordship, this notice was never served to me, so that 5-year time period has anyways expired. Even for this notice, since it was not served, it says that it has to be served within 5 years.
Well, I will extend it, don't worry.
Initially, notice was issued on October 2021. 6.
Taking into account that the instant proceedings have been interfered with on the ground of natural justice, on the technical ground of the principles of natural justice, the period from issuance of the show cause notice on 16/11/2021 till date be excluded, while computing the period of limitation in terms with the proviso to section 73(1).
73.
Is it under 70? It's not a case of fraud.
So there are 5
They have alleged.
Huh?
They have alleged fraud. It's a fraud. Normal
Is
period
it
is
fraud?
already expired.
How do
Yes,
you
they
know?
have issued. They have mentioned in the order
be excluded while initiating fresh process.
But Lordship, I may be given a liberty whether there is a fraud or not. Regarding that, I can make a submission.
No. Therefore, I'm not saying anything.
Yes.
You can very well reply. Full stop.
Yes. So that
Full
point
stop.
I can.
However, mandated me. Full stop. This court. Full stop. Included from so and so. No. While is excluded before initiating the first process. Huh? The observations so made herein above. No, full stop. The petitioner herein would be at number 4. Would be at liberty to take such defenses pursuant to receipt of the so-called notice as is available under law.
Yes. And Lordship, regarding the address also in the show cause notice, they should specify from where they have got. Just by mentioning Lakhimpur, it should not. In the notice, they should specify or give me the material from where they have got this
You
address.
can reply, na? If they give it to you now,
Yes.
saying that we have the jurisdiction or so and
Yes.
so, you can very well reply. That is why I'm
Yes.
not saying that. That you can
Okay.
very well, but that is open to you, na?
Okay.
Anything else required? No. Anything else, Mr. Jain?
No. Obliged.
With the above, the instant petition stands disposed.
Obliged.
Listed is it? Well, permission is it? Oh, it.
May it please your lordship.
Yes, what is your case?
Lordship, our application, your lordship will find that page number 20.
Just 1 minute.
Page 20, lordship, translated copy. Application for cancellation of illegal mutation and restoration of the names of the previous pattadars. May I read, madam?
Wait.
Respectful submission is that the land measuring 3 bigha 2 katha 16 lesa and 7 bigha 2 katha 14 lesa covered by DAG number 516/531 and 517/518, Patta number 69 and 117 respectively at village Lalabari under Matiar Avenue Circle are the lands in the name of our deceased father, number 1 Jagadindra Chaudhary, number 2 Jyotirindra
Mr. Counsel, why you are writing it to the settlement officer? What business does he have?
My lord, the settlement officer subsequently forwarded the application before the circle officer lordship and
Understood. Then,
and thereafter circle officer has issued a notice. That notice, your lordship will find at page number 23 by registering a miscellaneous case lordship. And thereafter, my lord, nothing was done lordship as on date.
yes, government. State, no state respondents. Huh?
We are not receiving the copy of.
You want somebody's name to be removed.
Yes, lordship. The correction of the name.
There's only the question that it has not been decided.
Decided
So-
lordship.
So early.
Direction is needed lordship to arrive at a logical conclusion of this application lordship. Since it is pending.
Copy is not with me, lordship. Petition copy is not with me, lordship. After some time,
You're a government advocate.
lordship.
I've never seen you here.
Today only I'm at a.
Get hold of a senior, anybody else, ask Ms. S. Sharma or somebody else. Let me get the instruction. I'll take it up after some time.
Lordship.
Get hold of some other one. It's no, এটা দুটা বজাত আছে না? কোনটো এইটো?
At 2 lots.
টু আছে নেকি? লেখা আছে। এটা লেখা আছে টু। Wait, there's another matter at 2.
Lots.
Lordship, I appear for the. Lordship, we have put in our additional affidavit as was directed by Lordships on the last occasion.
Hmm.
And
So
regarding
nothing
two
remains
paragraphs,
now.
nothing remains, Lordship, nothing remains. Your Lordship's last order in the same lines, the summons may be quashed, Lordship, and new summons for ESA sales, the DGGI Guwahati may issue a new summons and we will participate. We have
Why
put
new
in specific
summons?
paragraph.
Why
Lordship,
new
in the
summons?
existing summon,
Show
two
me the
parties are,
earliest. No, Mr. Kanoy, kindly show me the earlier summons.
Lordship, the summons, Lordship, the first summons is at page 52,
No, the last summons.
page
The
53, Lordship.
summons you have challenged, where is that?
Lordship, page 52 and 53, two summons.
52 and 53. Yeah.
52 has Rishi agencies and ESA sales, and 53 has Amazonite and ESA sales. So ESA sales is common in both. And Amazonite and Riddhi sales, they have to get closed. So Lordship, they may issue a new summon only for ESA
Let
sales.
it be there, but they would not further continue as regards Riddhi Industries and all. Let it be there.
And Amazonite. Lordship, let it be, Lordship.
Let it be there. I will bring on note that order and also that they are not going to take as regards Riddhi and Amazonite, and then on the basis thereof they can proceed with these summons only in respect to ESA.
Lordship, but now that I am okay with that, Lordship. Both the summons have ESA sales. So at least one summon has to go and one summon will continue.
Why?
Both the summons have ESA sales, Lordship. Kindly see 52.
Now, one is to Kanko and the other is to Parhi. These are different persons.
Lordship, it is the first they issue with the name of the company, then they issue with the name of the authorized person.
Understood.
It is a company, Lordship.
Oh, understood. But so both, why can't both remain?
Lordship, it will be same sum for same SSC, two summons for the
They
same
can't
subject.
be. One is a company and the other is the chief accountant,
Lordship,
financial officer.
company is represented by CFO, Lordship. Company cannot go in itself, Lordship.
Tomorrow the director may be brought in.
Lordship, that they have the power. That is not an issue, Lordship.
So
Anybody.
when it is given to the company, it will be the may also include the managing director. This is only
Lordship,
the chief financial officer.
Lord, I bow down
Let
there,
it be.
Lordship. I bow down. Lordship, may I just take your leave? I have a fixed matter in division bench in another court. My colleague will be there.
Okay. So then I'll pass the order to that effect, which will be similar that they will give up as regards Riddhi and Amazon Light, but however, investigation shall continue in respect to ISA.
Grateful, your Lordship. Grateful. Much obliged, Lordship.
Heard Mr. Suensu, the learned counsel, appearing on behalf of the petitioner. Mr. S.C. Kyle appears on behalf of the respondent number 1, 2, 3, 3, na? 4. Mr. B. Gugo appears for the respondent number 5 and 6. If the petitioner herein have challenged the summons dated 21/6/2024 and 5/7/2024. On the ground that the respondents, state authorities, have already given a report in respect to MS, the transactions pertaining to MS Riddhi Industries and MS Amazonite Steel Private Limited. And as such, the central authorities, that is the respondent number 3, does not have the jurisdiction in view of section 6(2) of the Central Goods and Service Tax Act 2017. It is the specific case of the petitioner that there cannot be two parallel proceedings. This court, by an order dated 26/7/2024, had issued notice thereby directing the respondent number 3 to apprise this court on as to whether the summons which have been impugned in the instant proceedings are in respect to the same subject matter for which the state unit have already investigated upon. In addition to that, the respondent number 5, who is an officer of the state unit, was also directed to apprise this court as to whether the impugned summons relate to the same investigation which was carried out and the report submitted by Annexure 9 to the writ petition. When the matter was listed on 30/8/2024, Mr. S. C. Kayal, the learned counsel appearing on behalf of the CGST, submitted that a matter of availment of utilization of irregular and inadmissible ITC from MS Riddhi Industries and MS Amazonite Steel Private Limited were under investigation with the state GST, and if approved, the same would be closed at the end of the central authorities as per the provisions of section 6(2) of the CGST Act 2017 to avoid parallel investigation in the same matter. The learned counsel further submitted that in respect to the ITC of rupees 19,04,328 from MS ISA Sales Private Limited during 2020-21, after cancellation of the GST registration, no other authority except the DGDI, Guwahati Zonal Unit can investigate. Authority about except the Guwahati Zonal Unit have initiated investigation as per the documents available. He further submitted that as per his instruction, the investigation in respect of MS ISA Sales Private Limited ought to be allowed to be continued. It was also submitted, this court also takes note of that on 30/8/2024, the learned counsel appearing on behalf of the petitioner also submitted that the petitioner has no objection in the investigation so carried out in respect of MS ISA Sales Private Limited. During the course of the hearing, the learned counsel for the petitioner had also placed before this court an instruction issued by the Assistant Commissioner of State Taxes, Sibsagar, to the Deputy Director General of GST Intelligence, dated 9/8/2024, wherein it has been mentioned that the input tax credit availed by the petitioner in respect to the parties, namely MS Riddhi Industries and MS Amazonite Steel Private Limited, are genuine and eligible. This court therefore directed the petitioner to file an additional affidavit in regard to their submissions and bring on record the said document dated 9/8/2024. In addition to that, this court had also asked Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent number 5 and 6, to verify the contents of the communication dated 9/8/2024 and make appropriate submissions. This court, pursuant to the order dated 30/8/2024, the petitioner had filed an affidavit whereby the communication letter dated 9/8/2024 issued by the Assistant Commissioner of State Taxes, Sibsagar, have been enclosed as Annexure A. This court have today heard Mr. A. Kanodia, the learned counsel appearing on behalf of the petitioner, who reiterated his submission that the petitioner has no objection in the question of going ahead and in the question of the investigation so carried out in respect of MS ISA Sales Private Limited. Mr. S.C. Gael, the learned counsel appearing on behalf of the respondent number 1 to 4, reiterated his submissions so made on the earlier occasion. Have reiterated his submission so made on 30/8/2024. Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent number 5 and 6, have also submitted that the document dated the document enclosed as Annexure A to the additional affidavit filed by the petitioner is a document issued by the state authorities. In view of the above statements and submissions so made, this court disposes of the instant petition with the following observations and directions. The respondent number 3 shall be at liberty to carry on the investigation in pursuance to the summons issued on 21/6/2024 and 5/7/2024. Insofar as MS ISA Sales Private Limited however, in view of the communication dated 9/8/2024, reference to which have been made herein above, and the submissions so made the submissions so made by the learned counsel appearing on behalf of the CGST, the respondent authorities, more particularly the respondent number 3, shall not carry out any further investigation in respect to the transactions with the petitioner in respect to such transaction of the petitioner pertaining of MS Riddhi Industries and MS Amazonite Steel Private Limited for the period. What is this period? Period
17-18.
Huh?
2017-18.
For the period 2017-18. Okay. Anything more, Mr. Das? Mr. Das, anything more?
Lordship also 1819, Lordship, there are two, 1718 and 1819, Lordship. We'll find it at page 8,
Page
8. Two assessment.
in respect to the assessment year.
1718 and 1819.
Where?
Lordship, page 8 of the writ petition, Lordship.
In respect to. And in respect to the period, which is on the basis of which the communication dated 9/8/2024 has been issued. Okay. Judgment good. Judgment good. लोगों में गया judgment to लोगों नहीं yes Prabhu sir, why are you not finishing up this matter?
On 15/12 notice was issued in earlier matter number.
Understood, but this has happened long time back, no? 2022.
Mentioned today, my lord.
Huh?
Has mentioned today, my lord, as unlisted matter.
No,
May I
understood.
have
We
today
do one thing. We will put it up on next Wednesday.
I may be allowed to have updated instructions.
Today is what? Let us have it on 18th.
Fine.
18th of September. Today is 16th, na? 9th. Let's have it on 18th. Get your instructions on this. Why the authorities have not disposed of this application? No, this matter should be disposed of immediately. One day matter.
It's a question of fact. This whole question of facts are involved. They say there might not
No. It's not a question of facts. It is a question of he is asking why it has not been disposed of.
He has made a representation for cancellation.
Understood.
That will be known, my lord, when my colleague will be producing but nonetheless, my lord, for cancellation of mutation, if the mutation order is there, so one will have to, because mutation order has to be passed by an authority under the law, either by the, normally it is by the additional district commissioner. Next time an appeal will lie. But nonetheless, without going for that.
No, the problem arises here that he moved the settlement officer.
Therefore,
He should have filed an appeal.
absolutely, that's all.
He should have filed an appeal against the settlement officer. But that is the big problem, Mr. Councillor. Why didn't you file an appeal? You can file an appeal before the DC.
We have representation.
What is this representation business? This is the mutation order, an appealable order. Representation can't do. You file an appeal before the DC.
Against the mutation.
I'll give you the liberty. The hook. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. R. Bapujari, the learned counsel appears on behalf of the respondent number one.
My lord.
Ms. M. Borman appears for the respondent number 2, 3, and 4.
My lord.
The petitioner herein. The petitioners herein have approached this court being aggrieved by the inaction on the part of the respondent number 4 in disposing of the application, the representation so submitted for cancellation of the mutation in favor of one Vibhu Bhushan Chaudhary, which was filed in the year 2018. 18, na?
18, Lordship. 29/11/2018.
I didn't read out. Pusto. From the materials on record, it transpires that the petitioner herein claims that late Jagadindra Chaudhary and Jyotindra Chaudhary were the original owners and possessors of a plot of land measuring 3 bighas, 2 kathas, 16 letters covered by patta number 152, new, 69 old, covered by dag number 516, of and included in patta number 152 new were owners and possessors of plots of land. The council, you should know how to write.
2 plots, sir.
Paragraph 2 of the writ petition, madam.
Huh?
Paragraph 2 of the writ petition.
Good work, na? Of dag number were original owners and possessors of 2 plots of land. One of such plot is dag number 516. One of such plot is a plot at measuring 3 bighas, 2 kathas, 16 letters covered by dag number 516 of patta number 152 new, 69 old. And the other plot is it measures 7 bighas, 2 katha, 14 letters covered by dag number 517 or patta number 152 new, 117 old at village Lalabari under Motia Revenue Circle in the district of Gwalpara, Assam. Good stop. It is the case of the petitioners that they have never, neither their predecessor in interest nor they have sold the said land. However, in the year 2015, they could come to learn that the 2 plots of land have been mutated in favor of one Vibhu Bhushan Chaudhary. Under such circumstances, the petitioner submitted an application on 29/11/2018 before the settlement officer Gwalpara, whereby the petitioner inter prayed for cancellation of the illegal mutation of their land in favor of Vibhu Bhushan Chaudhary and restore the names of the petitioners. Upon such an application being filed, the settlement officer forwarded the application to the circle officer of Motia Revenue Circle. And on the basis thereof, a miscase being miscase number 127/2022 was registered and notice was issued on 29/10/2022. Directing the parties to appear before the said authorities. However, there was no steps taken thereupon by the circle officer of the Motia Revenue Circle. And it is under such circumstances the petitioner has approached this court by filing the instant writ petition. I think better off, let me get your instructions. This court fixes this matter again on 18th of September 2024, on which date Ms. Emborn, the learned counsel appearing on behalf of the respondent number 4 shall apprise this court as regards as to what steps have been taken by the respondent number 4 in respect to the disposal of Miss Case number 127 of 2022. You come up on that day and say that, because you see a miscase has been registered. I have to quash the miscase otherwise.
Yes.
There the problem arises. Otherwise, if it was not registered as a miscase, the question would have been different.
But then again, also, my lord, circle officer may not have the jurisdiction.
Understood. He may not. He may come up with that thing that I don't have the jurisdiction, but he had issued notice. That is the problem.
That is the problem. And-
Alright. Upgraded item 6.
Yes.
Lordship, in the review petition, Lordship, the Honorable Court asks to submit documents, Lordship, as per order 19/12/2023, Lordship. And accordingly, Lordship, the petitioner dweller for 3 generation, Lordship. It is the question, Lordship, whether petitioner was the dweller for 3 generation or not, Lordship. 3 generation, Lordship. And may
Who are these?
Lordship,
Who are these people?
grandfather, Lordship, petitioner's grandfather, Lordship,
Your petitioner's grandfather's name is Gwala.
Lordship,
And what is your name?
Lordship Dasarath, Lordship Yadav, Lordship, Dasarath Yadav, Lordship.
Yadav and Gwala, how do you match it?
Lordship, my father name is Raghuvi Yadav, Lordship, and voter list also given, Lordship.
What?
Voter list of my grandfather has been shown as Lordship
What?
in voter list. Siurasan Gwala, Raghuvi, Lordship. Raghuvi is the father of
The land was transferred, your specific case in your writ petition was the land was transferred to you in the year 1992.
Lordship.
Now, what are all these 61 documents?
Lordship, earlier Lordship, my father and grandfather, Lordship has,
No. Your specific case is of 1992. It was transferred
Lordship.
on the basis of some
My
sale deed.
deed. My grandfather, Lordship.
Have acquired rights in respect to, you see, your space. What was your case? That a petitioner, upon making certain payments to one Renku Sera, and Logon Sierra claim to have acquired rights in respect to a plot of land measuring 13.5 bighas covered by dark number so and so in the year 19. No document, however, have been placed on record as to what basis the petitioner claimed to have acquired the said land from where. The facts are admitted that since 19 are in possession of the land. The petitioner has filed an application in the year before the divisional forest for mutating the land of so and so. To the said divisional forest sought for instruction as to whether the mutation process can be carried out or not. Pursuant thereto, so and so issued have observed that the act of mortgage of land and the claim of right over the land in question by the visit appears to be irregular and legally not permissible. We also observed that the orders which have been passed by the executive magistrate and in process of so and so, who is in charge of the Kaki as a party to the Iman. It is also observed that the status of the land in question being a reserve forest, Kaki River, irregular allotment of land to a particular individual with amount to violation of the provisions contained under the Iman as well as so and so. The respondent further directed the respondent number 3 that the basis of the instructions so provided by the communication submit a detailed report on the follow-up of the action taken by AI in the matter. Subsequent thereto, various notices were issued to the petitioner to appear before the authorities and produce. Thereafter, approached this court by filing the writ petition to the said the respondent number 3 has filed affidavit in opposition. In the said affidavit in opposition, it has been mentioned that the land where the petitioner is seeking allotment of mutation is a land falling under the Rampur Forest Reserve, Forest Village in Kaki Reserve, and the said reserve forest was notified by so and so. They also mentioned that the Rampur Day was constituted during 1955 with an area of Iman land from Iman household. The further stand taken by in the affidavit was that the occupation of the land of the since 90 is in violation of the rules of so and so. To the said affidavit, a reply has been filed. But your specific case is that you purchased in the year 1992. How do you take a completely different facts now? You're reopening something which is absolutely closed. Your case is different, and now can you come up with a review? And there is no mention. How are you saying that Shivasan Goala is your person?
Lordship, it's the voter list, Lordship.
What voters list? Voters list cannot be the basis on which Goala is your. How can it be? He is Goala, you are Yadav.
Lordship, page number.
And it is not known where. How are these relevant to you? How can this court take into account those new things? Absolutely new things are being produced now. The revenue receipts also do not show in which connection it is being given. Because your specific case was there. Huboson Goala.
Lordship.
Father's name is Lord Bochan. Son's name is who?
Raghubar, Lordship. My petitioner's
Roghubur.
Lordship.
Then Silosana.
Mother, Silosini mother, Lordship. Petitioner's mother.
You know this. Logon Seru, son of so and so. I have been possessing a plot of land measuring so and so. I have handed over the possession of the said 1 bighah of land to Dorsat Yadav. And from now onwards, he shall take possession of the land by mutating his name. This is your document. This is your case at page 66. This is on the basis of which you have. If this is the document on which you are relying upon, this was your case. This is the affidavit
Lordship.
on the basis of which you claim that your name should be included. This happened in 1992. How can there be a transfer of right or anything by way of this? How can this court take judicial notice of these documents?
Lordship,
On one hand, now you are bringing in old documents out there, which have no correlation with it. Your specific case is on a different aspect. Dan Potra. What is this Dan Potra? Who has given the Dan? He has given a gift deed.
give the
And there, this law is not applicable. Registration Act. Where is this? 6th schedule.
Lordship.
Huh?
Gifted.
This area? 6th
Uh,
schedule. This is Nagaon.
not.
No,
Yeah.
no.
Then what type of these documents are these? No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the review petitioners, and Mr. I. Pottaku, the learned counsel appearing on behalf of the Forest Department of the Government of Assam. The instant review application has been filed seeking review of the judgment and order dated 19/1/2022, passed in WPC number 7263/2015. On the ground that certain vital documents which were relevant to the dispute would not be traced out with due on the ground of discovery of new materials, new documents, discovery of documents which the petitioner could not place before this court at the time of filing of the writ petition. This court have perused the judgment and order dated 19/1/2022. From a perusal of the said judgment, it would be seen that the basic case that the case made out by the petitioners in the said petition is that two persons, namely Rengtu Cheru and Logon Cheru, have transferred the rights in respect of 13.5 bighas of land covered by Dag number 171 under Moza Kaki Kisan, Rampur Forest Village Kaki in the year 1992 in favor of the petitioners. It is further seen that the petitioners in the year 2014 requested the Divisional Forest Officer Nagaon to mutate the said land in their favor. The same was rejected, and it is under such circumstances the petition was filed. The same was written. The same upon being considered, the said application upon being considered, and the petitioners were being asked to submit the necessary documents, the petitioners approached this court by filing the instant writ petition. Therefore, from the above, it is seen that the basis of the entire basis of the petitioner's case, based upon purported acquisition of rights in respect to 13.5 bighas of land, covered by Dag number 171 under Moza Kaki Kisan, Rampur Forest Village in the year 1992. By way of the instant review petition, the petitioners have now sought to come up with a completely new case, whereby the petitioner now states that the petition, whereby the petitioner's case is that the petitioner's grandfather have been a resident of this, have been in possession of the said land since the last 3 decades. And the last how much? Not 3 decades.
Three generations.
Three
Three
generations.
generations.
No, wherein it is the case that the petitioner's predecessors have been in possession of the said land since the last 3 generations. And on the basis of that, certain revenue receipts have been placed. So certain receipts issued by the Forest Department of the Government of Assam have been placed. This court, however, finds it very pertinent to take note of that the said revenue receipts, said receipts issued by the Forest Department do not mention any dag or patta number. Even otherwise also, it is seen that the case set out in the writ petition is on the basis of acquisition of rights from the said Rengta Chiru and Logon Cheru in the year 1992 by the petitioners. The said documents have also been placed before this court, which shows that these are all unregistered documents having no force of law. Under such circumstances, in the opinion of this court, no case has been made up for review of the order, judgment and order dated 19/1/2022, for which the instant review petition stands dismissed. Last finished.
Masavi.
You see why? You see, I can do one thing. You withdraw the review and approach the officials. Because with these observations, it may hamper you. You withdraw the review and approach the officials with all these documents. What do you say?
Lordship, documents.
Whatever documents the officials may, because you see, if these observations are there, the case is finished. You may be evicted tomorrow. You came up before this court, you sought for mutation. Your mutation was rejected, not even rejected. You were asked to produce certain documents, then you came before the court, challenging the letter of the conservator of forests. Okay. And this court said that this is what it is. There's no right or whatsoever. On the basis of that 92 documents and all, there's no. Now you come up with a new case of 1961, 1958. Your grandfather was there. There couldn't be seen anything, a correlation between you and the grandfather.
Lordship, and liberty may be given to approach again after approaching the authority.
Heard Mr. So-and-so. The instant review petition has been filed, challenging, seeking review of the judgment and order dated so-and-so, passed in so-and-so. Upon hearing the learned counsels of the parties and this court bringing to the notice of the learned counsel to the effect that the case which had been set out in the review is completely a different case, which is the subject matter of the writ petition. The learned counsel submits that the review petitioners would not like to press the instant review petition. The the learned counsel further submits that these facts, these new materials which has come to light, if brought before the authorities, further submits that he may be permitted to approach the concerned respondent authorities with the materials which has come into light. Taking into account the above, the review petition stands closed on withdrawal. It is however observed that the judgment passed by this court on 19/1/2020, as well as the withdrawal of the review petition, shall not preclude the petitioner to approach the respondent authorities if so advised. I think this is a better order for your client. Something you can do, but with the other is finished. Division bench, nothing. Yes, what is this? Oh, that matter. What is happened? Supreme Court?
6th or 13th. 13th of September.
Otherwise, if you see the other judgment of the Supreme Court, there is a judgment of the Supreme Court which categorically says, I think Union Territory of Ladakh. Judgment by Vikramnath, Justice Vikramnath. Wherein it says that a matter being pending in the Supreme Court hardly makes a difference. Should not stop the court from deciding it. Your question is what?
Applicability of Limitation Act Section 5 in theoretic matters.
You got to stay now?
Yes, ma'am.
Enjoy. Leave it after 2 years. You're the bank. It has been submitted to the bar by the councils appearing on behalf of the parties that the matter, that the subject matter, the issue involved in the instant proceedings is likely to be listed on
13th of September.
13th of September before the Supreme Court. Taking into account the above, list this matter again on 5th of November 2024. Interim order passed earlier shall continue in the next stage.
So 7.
Yes.
Lordship, petitioner has been demised, Lordship. Petitioner has been demised, Lordship.
Petitioner have been demised. What is that type of submission?
Long back,
Lordship,
Lordship, long back, Lordship. As
Long
per
back.
Order 27/6.
Demised long back.
Due to miscommunication with the petitioner's family, Lordship.
Huh?
Due to miscommunication with the petitioner's family, Lordship. So we have not filed the substitution petition. Further 10 days time may be granted. Lordship.
What is the matter about? Setting aside the impugned order of the additional deputy commissioner in NR case. What did he do? You are paying for whom?
Correspondence project 427A.
This is an order passed by the Board of Revenue. When? Appeal disposed of. It is observed that 3 kathas of land cut off so and so. However, the matter is remanded to the Deputy Commissioner Borpeta for thorough inquiry and records. You are challenging which order? Heard admit so and so. 23/9/2009. What are you challenging? Setting aside querying. Setting aside the order dated 23 issue passed by the server, inserting the name of private respondent by cancelling the names of to dispose of the case, grant of suits. Oh, goodness. Yes, Mr. Barbudari, what is this case about?
This is a my lord. Tussle, my lord, between the petitioner and the private respondents.
Hmm.
And the petitioners say, my lord, that they are predecessor in interest, my lord, where, my lord, owners and pattadars of certain part and parcels of land, that dispute arose, my lord, between the petitioner and the private respondents. And one order was, my lord, passed, which lordship will find at page 23 of the writ petition.
Who has passed?
That order was passed, my lord, by the additional deputy commissioner, Borpeta,
27-1.
27-1.
Circular will correct the land records and so on. From the
Sir.
study of the NR case so and so, and anyway, it is found that there is no locus standi of starting an NR case upon disputed land. What is this NR case business? Non-renewal.
Yes,
This is a case of it's a annual patta.
yes, annual patta. The annual patta now, my lord, thereafter, that order was put to challenge before the Assam Board of Revenue. Assam Board of Revenue order, judgment lordship will find that
Expedient failed to submit any document
page
after
33.
proposing but in fact there exists no annual patta in the name of the party in the instant case. The land is controversy is simply government khas land. And the name in the chita in respect to the dag in question has been shown depending upon the original possession, which were originally merged in the act. We observe the 3 kathas of land cut out from the other dag number iman is patta number iman due to reasons of roadside land and in respect of certain limits of roadside record. That perhaps depending upon such situation of the region, no annual patta was granted to the possession of the land. How the matter is remanded for thorough scrutiny of the records and spot verification decide the issue of the incident following the observations made. Then what happened?
Then, my lord, it is also not put to challenge.
No, this order has not been challenged.
Order has not been challenged.
Then what remains? Tell me.
He challenges only, my lord, the order at, my lord, page 23.
And that has already been decided by the Board of Revenue.
And, my lord, in case of annual patta land, one who is in possession, my lord, naturally, my lord, mutation.
I'm
will
not
be
on
affected.
that, but fact remains,
Yes.
the order of the Deputy Commissioner, the Board of Revenue having not challenged, which
Yes.
has attained finality,
Yes,
nothing remains.
Nothing remains. So he
How
has
is this matter pending since 2016? 13? My goodness. Hello. It has been submitted by the learned.
Writ petition has abated. Writ petition has abated, my lord. The petitioner has expired since long.
No, I wanted only not for other reason. Why I am saying so is because not only the abatement aspect, but whether anything survives in the petition.
On merits also nothing, sir.
Because without a challenge to that order, that
Yes.
is what I'm saying. Why I looked into that.
Yes, lordship is correct.
The counsel appearing on behalf of the petitioner had submitted that the petitioner have long expired. Good stop. What's your name? So and so appearing on behalf of the private respondents submitted what? Submitted that the petitioner had long expired and they knowingly have the legal representatives knows about the instant proceedings but they have not chosen to substitute. She further submitted the instant case also cannot be maintained taking into account that the order passed by the Deputy Commissioner dated passed by the Board of Revenue dated 28/6/2010 in case number 49 RA bracket B/09 have already attained finality and there is no challenge to the said order. taking into account the above, this court is of the opinion that as the petitioner, as the legal representatives of the petitioner have not shown any interest in substitution of the original petition, this court is not in a position to further proceed with the instant writ petition at the instead of at the instance of a dead person. Accordingly, the instant writ petition stands closed. Does the concept of abatement come in writ? How?
Because my lord, there are some one or two decisions, my lord, I have. But
It's being done, it's a different thing. But how? Abatement concept doesn't come. Abatement has to be on the basis of law.
abatement has to be in law. basis
On the
of
basis of law. The law is on the basis of the species.
decision. Now, my lord, in 226 proceedings, my lord.
How do you do it? In view of 141.
141 is there. We have been, my lord, some.
So therefore you put it like this, no? You can't proceed at the instance of a dead person.
Yes, that is also other. Well, that Devi versus state of Kerala, my lord.
So
Otherwise,
therefore,
if otherwise, my lord, order 22 is not affected, then my lord, order 1 rule 10, that will come.
you can't proceed at the instance of a dead
Instance
person.
of a dead person. There may be occasion, my lord, where substitution may not arise, but there has to be legal penalty. And so,
Because there is no abatement, there is no, because limitation act will not come.
it doesn't actually not come. Yes.
So how do you bring in abatement?
Yes. Well, that 90 days period is, that is true, my lord. I am obliged.
Yes, Mr. Bolwa, what is this matter?
This writ petition was filed seeking an investigation into the matter by an independent agency
Why?
other than the Assam police, because this matter has been pending since long and no progress in investigation has been made.
Responsibility and accountability of the deliberate inaction on the part of the respondents, specifically the respondent for not carrying out the investigation in Dalgaon. Hand over the investigation of ER to Iman. Why?
My lord, an FIR was registered way back in 2006, and then 3 FIRs were filed, and these 3 FIRs had to be filed because the London magistrate was not satisfied with the investigation that was done. So, in the last order, the magistrate also directed that further investigation should be done because some apparent failure on the IO was found and recorded in the order. And thereafter, there has been no progress in the investigation. And hence, we were constrained to approach this court once again. In the
Well,
previous
what is the magistrate doing?
my lord, we had filed a petition before the magistrate saying that this the final report should not be admitted because the evidences of me as well
Final
as,
report submitted.
yes, it was submitted.
Then what
But
did you
then
do?
we submitted an objection against that, saying that necessary evidences were not recorded. Therefore, even if it goes to trial or if that final report is admitted, then prejudice would be caused to me.
Then
So
what?
the learned magistrate was pleased to direct the further investigation of this matter.
Then
And thereafter, no progress
so
has
the
been.
magistrate has to keep the matter.
Yes,
Has the FR been accepted?
no.
Then why the magistrate is not taking up the issue?
My lord, if I may kindly draw your lordship's attention to the order of the learned magistrate at page number 160, the relevant portion.
Huh?
160, my lord, of the petition, the last page. The last para, my lord. Page 160.
This court going through the case record and indeed find that the IO investigated the case perfunctorily. It revealed from the final report that the IO has investigated the case properly. Not to Iman stated the and IO submitted the FR as per the verbal instruction of the Iman coordinator. It shows the investigation was hence in view of the above, the prayer of the informant direct the CBI in my instance rejected. The prayer to refer the case to the Honorable to have a fresh inquiry to the Iman is rejected. However, the final report file is not accepted. For the angel, I direct the Iman Here the problem arises. How can he reinvestigate?
And actually, perhaps the
No,
learned
no,
court
there's a
suggested
difference, Mr.
for
Bhutta.
further investigation, madam. Because the word here is,
Therefore, the problem arises with this order.
yes, reinvestigate the case further.
How can he reinvestigate? The reinvestigation means a fresh investigation.
Yes.
But a further investigation is only for the purpose of carrying
Yes.
ahead with what has been done.
Yes.
So therefore, the matter is not pending.
No, my lord, the phrase, my lord, is to reinvestigate the case further. So perhaps what the learned court meant
Understood.
was further.
Therefore, he should have asked for that.
So it was stated that let the case diary be sent to the officer in charge concerned. Also send a copy to so and DGP and SP for compliance of the order. The instant case is kept in abeyance until further order.
Yes, madam, what have you done as regards the investigation? Pursuant to this order?
Lordship, in this with humble submission, my lord, this matter was earlier dealt by K. Gugoi, my lord, post of Gugoi. He is somehow in difficulty right now, my lord.
I spoke with him
On
just a few minutes back. He said that the learned counsel will handle the case.
probably I was informed.
My
it
lord,
is
on
silent.
the last
Station?
Dolga police station.
In case, my lord, as per last.
My lord, may
instruction,
kindly peruse the
it
last
also-
order, my lord.
List this matter again on,
My lord, may kindly peruse the last order.
list the matter again on 29/2024, on which state Ms. M. Borman shall obtain an update from the investigating officer of Dolgaon Police Station case number. Investigator of Dolgaon PS case number 278/06 as to what as regards the status of investigation pursuant to the order dated 6/4/2013 in GR case number 3599/2009. What is this matter about?
My lord, there were allegations of theft in the shop premises and residence premises of the petitioner. And those whose name were alleged, one of them was an ACS officer at that point of time. And therefore, it was my apprehension that because of the high-handedness of the police officers, the investigation was not carried out in
Chalo.
true spirit.
Madam, you get your instructions.
Okay.
On 21/29/2024 at the top of the list. Top of the list. Get your instruction.
I'm so obliged.
Hard Hall. Tanuka for Tribal Affairs. Yes. You recently been arraigned as the respondent and since prayer is not opposed, just to clarify. Yes, what is this matter about?
My lord, our prayer is this jungle block part 2 within Rabha Hassan Autonomous Council area should be excluded from that area because there are only 28% of Rabha people. And 72% are.
That was the Tiwa matter, na? Have you gone ahead with the Rabha? You said on the last occasion here. Mr. K. Gugoi, are you appearing in the earlier matter? You get your Inspector AR Humni K. Gugoi naam to didi. I've asked them to get an status report as regards the investigation pursuant to the order dated 6/4/2023 in that case. And from the investigating officer. I'm fixing it on 29/2000 at the top of the list. Get your instruction on that. Because this matter, the mistake has been done. The court could not have kept it for any abeyance. Further investigation asks you a report. That is what the problem is. Yes.
My lord, basically what I understand from this, from the writ petition, my lord, page number 25, my lord, page number 25 of the writ petition, this clause 4, my lord, they are aggrieved by that.
There shall be a village council for every
Each
block
block
and each village.
Having 50% or more of Rava population, this is of 95, my lord, this is 95 act. 50%, they say that their population is less. So, my lord, then in 2021, this was amended and it became from Rava, it became tribal. That part was 50% tribal. Now, my lord, what happened? Recently, my lord, in 2024, I think my senior, I'm not very much aware whether this, I'm just placing, again, it was amended and this whole section has been taken out. My lord, deleted.
Or is no longer there.
Village, yes, my lord. So, my lord, this part, I'm just placing it before lordship. So, my lord, I was also really confused. So, that is what, my lord, after this, my lord, what happens next? If this, my lord, is orange flag, my lord. My lord will find
In the Principal Act, Section 4 has been
section 4.
omitted.
This is the section 4, my lord.
Now, has it been notified?
Yes, my lord. This is notified, my lord.
How do you know?
My lord,
It shall come into force at once.
the previous page, my lord.
So nothing remains.
So, my lord, this part, so I don't know
No, if that
what
place
affects.
is, if that is excluded, well, they have filed affidavit, it is silent about that.
My lord, that is
But
that
Mr.
affidavit.
Mahmood, the question is, it's an act. You have to challenge Section 4 of the, you have to challenge this act, amending it. As of now, can this court issue a writ?
No, I understand that, but thing is, this fellow, when they have filed affidavit,
That
that should have been
some 7
disclosed.
years back, my lord.
That should have been
When
disclosed.
did they file the affidavit?
Yes, that is, we have received on 11/5/15.
15.
It was filed by.
Now,
Yes.
Mr.
that-
Mahmood, this is 2022.
No, that I understand, but
You challenge this. Yeah, what this?
I can give a copy of this act to him.
You give it to him.
it is not within our knowledge because in
You know,
affidavit,
I
it
have
did not
heard
disclose
Mr. M.U. Mahmood, the learned counsel, appearing on behalf of the petitioner. Mr. So and so. You have done that for the Tiva also.
No, my lord, no, my lord. That will, my lord. Today morning I called up and they said, my lord, now more to consistency has to be brought in. So now they are again modifying that order that delimitation has been stayed.
No, Mr. Mahmood, why I'm saying is, and Mr. Ardhor appears on behalf of the respondent numbers 1, 1 and 2. Respondent number 2. The
There is four
petitioner herein have challenged the
inclusion of jungle
the
block.
impugned notification dated 17/5/2005, so far it relates in inclusion of village jungle block part 2 within Rabha, what is that? Rabha Hasong Autonomous Council in the district of Gwalpara, as well as the impugned order dated 16/12/2023 passed by the respondent number 1 in not excluding the village Jongle Block Part 2 from Rabha Hasong Autonomous Council area. The case of the case of the petitioner is based upon Section 4 of the Rabha Hasong Autonomous Council Act 1995, which at the time of filing of the writ petition was in existence. However, it has been brought to the attention of this court that by an amendment made to the Rabha Hasong Autonomous Council Act 1995 by the Rabha Hasong Autonomous Council Amendment Act 2024, which came into effect on 15th of March 2024. Section 4 have been omitted. Taking into account the above, the instant writ petition therefore cannot survive. Accordingly, the instant writ petition stands closed. However, it is made clear that the petitioner, that the closing of the instant writ petition shall not preclude the petitioner to, where's that act? To, shall not affect the petitioner to To challenge the amending act, if so advised.
For exclusion of that place. Because only.
No, challenging, unless you challenge, because what has happened, that is why I said whether the delimitation is possible. Now, what they have done, kindly see this. Section 3 have also been amended. 3.1. Thereby, what they have done, they have removed the village councils. So the village council concept is gone. So unless you challenge this, nothing remains. That's the problem. That is why I wanted to give you the liberty in the delimitation proceedings, but village council is removed.
All right. My lord, may keep this as a part. Deeply.
For 10 and 11.
What is this?
Lordship, in this matter, we are seeking compensation from the respondent number 3, who is Coal India Limited, for degradation of our land, Lordship, which has been caused by the open cast mining done by them,
Why?
by Coal India Limited, Lordship.
Pay compensation as assessed by the district administration for damage, degradation caused to the cultivable land of the petitioner due to open mining, cast mining of the coal in the area. Then, what do they say?
Lordship, they have been dilly-dallying the matter for quite some time on the pretext of filing one petition after another, Lordship. There have been several rounds of litigation. Lordship, an amount of 2 crore.
What do they say out there in the affidavit? Hmm?
If Lordship permits, could I?
And what is this affidavit filed by whom? Who has filed this affidavit? Affidavit filed by respondent number 7. Who is he?
Lordship, there is another analogous matter in this.
Secretary Lido Sonali Gao Kothar.
So Lordship, in the second case, that is 2408, that gets been filed by us, in Coal India Limited. In that case, they filed this affidavit.
Who?
The petitioner in the first case.
Oh, you have filed an affidavit as respondent number 7.
Yes, Lordship.
In the
Second case is filed by who?
second case by us.
Challenging the district administration's direction to pay. Why?
Mainly, your Lordship, that's the.
You want to file reply? No.
You can file otherwise.
No, if you don't want to file, don't file. Tell me. What is the ground for challenging?
Because the fact remains, this is the 8th number of litigations, your Lordship.
Huh?
8th round of litigations, your Lordship. The case started from the year 2001. The case, then the case pertains to the alleged compensation for degradation of the land by Coal India Limited. And your Lordship, what happened in the year 2006, in our absence, the district authority, they made an assessment and determined a compensation of 4 crores 61 rupees, 4 crores 61 lakhs or compensation, which was done in our absence. Then we came before this honorable court. This court, by order dated, the Lordship, in the second case.
No. The thing is, why this is being going on like this?
Because your lordship,
What is the what is the basis on which you measure the degradation? And who is the authority to decide?
because nothing remain, because the district authorities, they determine the compensation in our absence.
No, understood.
And we
How, what is the basis of the district administration taking up that jurisdiction under what provision?
Yes, that was not.
Under what provision you have taken up the jurisdiction?
Direction of the honorable court.
No, this court cannot be a lawmaker. There has to be on the basis of something. If it is done on the basis of the directions passed by this court, then if something has happened, how do you assess?
And that.
Then it is why a writ is being filed.
And that assessment was done, yeah, without following any procedure.
No, there was a direction passed by this court. Where is the direction, madam?
Annexure 2, Lordship,
Of
of 7173, Lordship, page number 27.
your writ petition or their writ petition?
Our writ,
Page
27.
70?
27.
Page 27, Lordship.
Page 27. This is the direction. Heard Mr. A.B. Chaudhary, in view of the cited demand, Assam, and having gone through the governments and contentions media, disclosure of the ends of justice, the Deputy Commissioner is directed to verify the claim of the demand on the basis of the materials available and to make an inquiry for the assessment and also calculate the compensation payable to the members of Iman as expeditiously as possible, preferably within 4 months from the Iman, and to refer the matter thereafter to the respondent number 5 for consideration and payment within a period of 2 months. So this was the direction.
This was the direction.
Now, what basis does this court give that direction?
Lordship, Lordship, may kindly peruse annexure number 7.
Huh?
Annexure number 7, Lordship, page number 58.
Page?
58, Lordship. This is the report of the subdivisional
Yes,
agricultural
Annexure
officer.
7. Submitting of the report. And also land becomes uncultivable and unsuitable in the adjacent fields along with Nala and besides so and so, but due to a polluted, contaminated water as reported in so and so. Then what happened?
Lordship, thereafter we preferred several representations before them. It was not considered, hence we moved before this honorable court.
This is the minutes. Annexure 9.
Lordship, it was
Joint verification, the earlier assessed amount of rupees so and so to the members of the Lido Hunaba project is agreeable to the committee. However, Coleman did not agree to the proposal of the payment of the aforesaid amount as the assessment was not prepared jointly and compensation was already paid during the period from 93 to 95. Now there is no damage.
Lordship. If Lordship permits, may I, Lordship place the facts on record, Lordship.
No, not necessary. But I'm asking you now, is there any damage?
Lordship, now there is no damage. We have been asking this
So
compensation.
we are
for the,
concerned about the compensation for the period from 93 to 95.
89 to 95.
So you want to go further beyond?
89 to 2006, Lordship, it is that.
89 to?
2006.
Now, if it is for 89 to 2006, then why they are considering only for the period from 93 to 95?
Lordship, that is only with regard to 28 petitioners, which they claim they have paid. However, there are 108 families. We are on behalf of that 108 families. Only 28 were paid. A nominal amount was paid by them, and that was the amount calculated. Only for 2 people.
Now, where does the deputy commissioner look into that? Aspect?
Yes, Lordship, that has been taken into account, and moreover, they
Where?
Lordship.
In your petition, where is it?
If Lordship, second, is this one. Annexure number 4, Lordship, page number 36.
Page?
36, Lordship.
In pursuant to the order dated so and so on the date of hearing of so and so, Iman Bonia so and so, as per the order dated on This is of 2008.
Yes, Lordship.
Yeah.
Lordship, may kindly
In the
please.
period, Iman, the learned advocate for the appellant has also submitted the and compensated on. Appellant is who? And some of the members of the
All India Limited.
we are taking by executing an agreement stating that they have correctly meetings. Apart from the fact that if some victims were involved. Then, after that, who challenged this? This was challenged.
After that, they again challenged that they are
And
not
what
willing to
happened?
pay this amount.
Yes.
Thereafter, Lordship,
That order, your lordship, the most crucial thing is your lordship.
they said that a joint verification has to be conducted in the presence of all the parties. Lordship.
To carry out a fresh exercise with participation of both contesting member and they should be completed and preferably within 3 months. Then
Thereafter, they were intimated that.
a writ appeal filed.
Yes.
Writ appeal filed. What is a writ appeal say? The learned secretary said you have to make an on-spot inspection and giving of that people. Okay, then
They were
report being
intimated
made
a
after
joint
on-spot
verification was
exam and
conducted,
this is the
Lordship.
amount. Okay, done. Tell me, what is wrong?
Your lordship, the facts is partial. Lordship, because against that order, we filed one writ petition in the year 2000.
Now, why you should not pay interest on this amount? No.
Your
I'm
lordship,
not on the other thing.
Your lordship can come to.
You see,
Election
kindly show me you have paid from your documents, you have paid more than the 28% or the petitioners have been paid. Show me that.
Your lordship.
Mr.
that order
Counsel,
was
I am not
silenced.
on the other aspect.
Your lordship
No,
can
Mr.
come to
Counsel,
an act of
no,
complaint.
nothing. Mr. Counsel, kindly come back on, kindly make it clear. As to whether you have paid the petitions.
Yes, your lordship.
Where?
We-
Show me. Show me that.
No.
Otherwise, I'm not concerned with other things. Your petition, I will dismiss it then. Come here, come on.
Your lordship, that order which challenge and this.
No, forget about all these orders. I've
Yes.
got the understanding what is there. First, Justice
Yes, yes.
Saikia passes an order to the effect,
Yes.
asking the
No,
deputy commissioner to make this.
Your lordship, facts are where. Your lordship kindly come to page number 138 to 145 of our petition. Just kindly come to that.
Why?
That because subsequently we filed one writ petition. That writ petition was disposed of by this honorable court, and that order your lordship can come to our petition.
Huh?
At page number 145 your lordship, to our petition.
145,
Yes.
what does it say?
Yes, subsequently we filed a writ petition. Then they went to the appeal. Thereafter they made it.
I read that order, passed by the division bench of Justice Sridhar Rao.
So, yes, thereafter, your lordship, thereafter the meeting was held in that meeting, the learned deputy commissioner said that the joint verification is not possible because this order, this amount, 2 crore something was calculated on the basis of an earlier joint verification wherein we are not the party. But now the thing is that the deputy commissioner, that the revenue authorities, on what basis they calculate?
Now the
cost?
question is whether the
So we
petitioner,
challenge-
no, are the petitioners using the land?
As of now, they cannot cultivate lordship.
They cannot cultivate. Okay. Now, whether there was a joint verification, there seems to be a joint
Yes,
verification.
lordship, initially there was an objection to which.
No, no, there is an order of the
Yes, lordship, the joint
the
verification.
subdivisional officer,
Yes, lordship, a
which
joint.
I could see just after, before that minutes.
No, yet.
There is. What
Yes,
no?
lordship, a joint verification was done. Joint
This
verification was
doesn't
done.
take time.
No.
These are-
That was done.
Kindly see page 58.
Case
Page 58. Submitting of the report on losses and damage submitted by the open cast mining. This is it. And pursuant thereto, you came up with this. Yeah. Huh?
Page
Page
58 is
58.
the report of the
Page 58.
subdivisional officer with regard to the toxicity of the landlord.
Yes.
No, but what authority they, but. this
What authority?
Yes,
First of all, I am asking you, what authority you have to destroy their lands?
Oh.
No. You acquire their lands. You cannot.
audit we pay, your lordship, we
Mr.
pay-
Counsel, these courts were very lenient on you.
Yes,
This is
Yes,
no
sir.
question of leniency. Here is a case you have taken their rights under 300A. They have a right in respect to those lands
Yes.
which have now become unusable. The amount of loss, the agony which has gone to the petitioners, you have to compensate.
no,
This is not the manner. Come up with all these things.
that
This
is
is
true.
now, this
we-
court is not only going to consider that 2,31,000. You have to pay interest from 1995 at the rate of 9% for the first year, 15% from the second year. You have made them people not to use. For the last 2 decades, they have not been able to use their land. My goodness. And the audacity of the year, this is a peltry amount for Coal India like this, 2,32 crores, 31 lakhs is peltry. So
Yes.
why you are not making the payment?
no.
You
That-
don't come up
yes.
with this type of
Yes.
idea.
Your lordship,
Think
we paid the amount in the year 93 itself. For that
Therefore,
year-
I am asking you, kindly show me, don't come make a submission. As per the report of the person who have been authorized by this court, they say that only 28 persons have been paid, others have not. Kindly show me that you have paid all the petitioners. Show me that document. Show me that document. Don't come up with all these things. This is not a case by which you came and did delay out there. Now why you should not pay interest? Tell me that at 15% per interest from 96 onwards.
Your lordship, yes,
You come up with that answer.
I can understand, your lordship, but the thing is that
15% interest on 2 crores, 31 lakhs from 96 first is 9%.
no, that is true. But our case is that,
This is
that
not
on what basis the
nothing doing. This is to be dismissed. Your petition is to be dismissed with that cost of 2 crores only. Absolutely. You can't do all these things. When the court have asked you that you cannot, this is the right which have been taken of you. And there is a direction, there is a fact-finding inquiry. What is this joint inspection you want to be there? Joint inspection, if it is there, are you disputing the joint inspection?
Yes, your lordship.
What are you disputing?
Your lordship, the
Have you
purpose-
made an inspection? Have you made an inspection? How much area as per you have been demolished, destroyed? Tell me.
The-
How much is the area as per your report? You must be having some reports on the basis of which you say, you can't dispute just, oh, I am not there. Nothing doing. You are after a state. You have to come up with this thing. What is your basis? Tell me.
Your lordship, first of all, your lordship, whether that they are claiming that 530 odd bigger, but whether that land was actually degraded for coal mining operation performed by us, that was not true.
Have you forget of them proving it? That is what the fact-finding inquiry
Yes.
have done.
Yes.
Do you have any evidence which is against that? Have you made any inquiry by yourself? You are after all a state. Remember that. You can't come up with all these
Yes,
things.
yes,
Then
it is the reason.
money,
we
you
sought
can't
for
pay
the
these
deputy
people out
commissioner
there
to
who
come
have
and
been
have a-
all being deprived from 1995. This is a peltry sum of 2 crores.
It is true,
Yeah.
Your Lordship, well, that is true, Your Lordship,
When you are paying,
but the thing is that
when are you paying that amount? Then we'll consider what is the interest. Payment when is to be made. This is not thing to do with all these things. I am very particular. These type of things is a serious infraction. I will ask the best order you can get it. I'll ask the deputy commissioner to find out, give you, and the courts have given that.
Yes.
You are to pay as per that, unless you challenge. Have you challenged any of the orders of the Justice Rishikesh Roy?
yes.
Where you did not challenge it?
No, no,
No,
they,
we didn't
they,
find
Forget
it.
about them. They challenged it.
challenge-
No, Mr.
Your Lordship
Counsel.
will come- your-
Mr. Counsel, listen. They challenge it on the ground that there is no requirement of a joint inspection because already an inspection has happened.
Yes, Your Lordship.
But the division bench said no, the joint inspection is there.
Yes,
But
sir.
Justice Rishikesh Roy's order is very specific also to the effect that the inspection will be done, they will make the assessment and you are to pay within 3 months. Why haven't you paid that? I'm not on that. You should have challenged that. You should have challenged that order. You can't do that. When they, after they filed the petition, you have come before this court.
That is the reason why we approach the deputy commissioner and we are ready to pay the reasonable amount. We are ready to pay. That is the
What?
reason why.
You are ready to pay?
We are ready to pay the reasonable amount. What they are actually.
They have already made a joint inspection. Therefore, unless you come up with something to show that there was some other lands are there, you must have made an assessment. You are the person who have destroyed their fields. You must have made an assessment. You could not have destroyed any of the fields. How could you have destroyed somebody else's fields? They have been doing without this agriculture. These are farmers.
Yes, that we can understand, but whether their land.
I'm not concerned with that. When are you paying this amount? I'm considered. Then I'll consider the interest, 15%.
Then there was some other day, you're also minus.
Yes, other day only. When you are paying that, that is why I'm saying nothing doing. Then I'll consider interest.
Then my senior person, Mr. Andrew.
In your new senior, I'm not bothered to that effect. You are to pay that amount. This matter again on 23rd of September 2024 at the top of the list on which state the learned counsel appearing on behalf of the writ petitioner. Appearing on behalf of the Northeast Coalfields shall apprise as to when the said authority is paying the amount to the petitioner, paying the amount to the district administration for onward dispersal as per the findings, as per the quantifications so made by the district administration.
Lordship, could it be on 24th? 24th.
Huh?
On 24th.
Miss Madam, I don't need to hear you any further. 24th, no. 23rd, I'm taking it at the top of the list. Come up as item 1. You come up with that amount. How much you are going to pay? This encourages.
Because
It's a very serious thing which you have done.
yes, sir, so I can understand, but
I don't understand. This is for the first time it is. Litigations after litigations after litigations, and these people have been deprived. I only have a bit something. I know you are into coal fields. The coal fields is dark. The heart may be dark, but that doesn't mean that you are not going to be.
No,
The people who are managing the coal fields should not also be having. You may have a very big out there, the black diamond towers.
no, that is not.
Don't come up with all this. You
Your
have to
we-
pay that amount.
We are.
No, no, no.
But that amount which.
This amount needs to be paid. Come up with this. You pay the amount, then we'll consider. It's not the case. First of all, this court should not have admitted your petition on the first day itself. Should have made that prayer on the basis of payment of that. We'll consider it. But yes, 8 rounds of litigations and the cost of the litigation and the cost for filing an litigation. There's a stake.
State your lordship, but the
Please
thing is
there.
that whether.
Interim
whether-
orders passed earliest and vacated.
Because it has not come to light whether those lands were degraded by us or not. Okay. but
I
it-
am
next-
on the question, Mr. Counsel, whether you have any other evidence. You see, kindly see the minutes of the meeting. Minutes of the meeting say that in respect to where there is a double payment, there is no requirement. As regards the 28%, not required. So you kindly come up with your stand to that effect that you are ready to pay subject to, I'll ask the district commissioner to make the verification, whatever may be, and then to pay. But this payment will be subject to interest. Telling you. On 23rd, this is the order.
You're against an order passed by the ombudsman, Your Lordship.
Ombudsman?
Lordship,
What are you
banking
doing with the ombudsman business?
Banking ombudsman, Your Lordship, actually, these matters are not appealable, so we don't have any other forum to approve. Finding no alternative, we are before Your Lordship.
Why? Why ombudsman order is being challenged here?
Yes, we are mainly aggrieved by two things, Your Lordship. We have availed two kinds of facilities from the private bank, Axis Bank, Your Lordship. One is cash credit and other is bank guarantee. And after availing the facility of cash credit for 4 years, it was sanctioned for a period of 12 months, then automatically it keeps on renewing. And accordingly, we enjoyed the facility for 4 years. Thereafter, we wanted to shift the entire loan to ICICI Bank, another bank. And they chose a penalty which they named as prepayment charge. My contention is on cash credit account, there cannot be any prepayment charge, Your Lordship. That is one. And second is the bank guarantee. They have charged commission on bank guarantee illegally because we once the bank guarantee are released and they are no longer in use, they cannot charge any commission on
Who
that.
is this?
So these are
Axis
the
Bank?
two
Yes, sir.
Axis Bank.
Where is the ombudsman order?
Yes,
It is at page
156, 156, Lordship.
156.
56.
Please refer to your complaint dated on Iman India. It has been observed that there is no deficiency of service in regard to asking penal charges of 2% by Axis Bank. Subject matter of grievance pertains to bank guarantee, which does not fall under purview of Iman. Therefore, it has to close the case under 13A. So you are asking for the bank guarantee also? A
Lordship, the
refund on
commission-
it, because the
commission- the
refund, bank
commission.
guarantee aspect, the ombudsman did not decide.
Okay, the commission on bank guarantee, Lordship.
No, bank guarantee aspect, the ombudsman did not decide. The bank, only the ombudsman decided as regards the penalty of 2%.
That too by a single order without going to the merits of the case. That too by way of a single order that there is.
How
no
many
deficiency.
orders are required?
The only thing is that they have stated that there is no deficiency in service, that's it. And no opportunity was also given to us to place our case before the ombudsman. They have violated the principle of necessary justice also.
There is a banking ombudsman rules, na?
Yes. Yes.
Where is that? Section 9 or something?
No copy of that. Put it. Put it.
You have the banking ombudsman rules?
Yes, yes. The banking ombudsman scheme 2006. I have a copy, one copy only I have.
Okay, section 9, rule 9 or something?
Procedure for filing.
And no, not rule 9, 13.
Rejection of the complaint.
13 or 12 or something. Maybe.
Yes. 13, salary.
No, what is the manner in which it is to be done?
Yes, the banking ombudsman may reject the complaint at any stage if it appears to him that the complaint made is not on the ground of complaint referred to in clause 8 or otherwise not accordance with subclause 3 of clause 9 and beyond the pecuniary jurisdiction of banking ombudsman, requiring consideration of elaborate documentary and oral evidence and the proceedings before the banking ombudsman are not appropriate for adjudication of such complaint without any sufficient cause or that it is not pursued by the complainant with reasonable diligence. That it is not pursued by the complainant with reasonable diligence.
No.
Or in the opinion of banking ombudsman, there is no loss or damage or
What does
inconvenience
14
caused to
say?
the complainant.
14,
Appeal before the appellate authority. Appeal before the appellate authority.
Why will not file appeal?
Because this the order itself will, if your lordship may kindly come to page 156 once again. The second paragraph, the rejection of complaint under provision of clause 13A of the banking ombudsman scheme is not applicable. In fact, it is not applicable because appeal.
Yeah, show me that rules. There is another insurance ombudsman is different.
Yes, yes, it's different.
Insurance.
It's different.
Yeah, that is what now you are not doing it. 12(1). 12, section 12. Only.
Okay, then you come. Good.
Anyways, the question is twofold. First is whether there can be a 2% penalty charge.
Yes, sir.
Now, whether for closing a cash credit loan.
Yes, credit.
So it will be there in your agreement.
Yes, it is in the page number, your lordship, in my sanction.
Where?
Is that page number 122 is the sanction and prepayment is at
Page
125. 122 is the sanction advice.
Prepayment penal
and-
charges at the rate of 2% in the charge in case of prepayment or takeover of the working capital credit before 1 year from the date of sanction.
And
Thereafter, no prepayment charges applicable for the working capital.
commission on the bank guarantee is at page number 124.
124.
Yes, it is specified as 1.5%. And it is in single payment, your lordship. When the-
Where, commission?
Yes, your lordship,
1.5%,
B4.
50% of the bank's standard. This is for bank guarantee.
bank guarantee. What
So
they
how
have,
you have taken commission of 1.5?
1.5% at the time of issuance of the,
Huh?
at the time of issuance of the bank guarantee.
That is being challenged.
Yes, that is it. It is basically a private contract.
After regarding the prepayment on cash credit, I'll have to explain why I'm not entitled to, they are not entitled to charge your lordship. The initial sanction letter, your lordship.
No, we are only concerned with these sanction letters. Why should you go for initial later? But you have not challenged this, no?
Because
That is of 25th of November 2014.
Yes, sir.
This is the sanction letter. Cash credit 10 limit and 8. So you mean to say, you see cash credit, if you don't use it,
Yes.
then where is the question of prepayment?
No, actually not on that. I'm not on that, your lordship. Cash credit account operates like this. Once I take account amount of money from that account, then only interest is leviable. And I can always put the money back in the account and and if so I remit the entire amount back, then the debit balance will be 0. And after that, I'll be not charged any interest. So this is how the cash credit account operates. Now my case is, your lordship. On a given day, I gave an application to the bank that this entire loan facility will be taken over by another bank. And on that day, that cash credit account was operative. It was operative. So there is no question of prepayment charge or anything. Then the other bank remitted the entire amount of money to them. Then also the bank account was operative, but there was zero debit balance. So no interest was leviable, nothing. Subsequently, the bank came up with a letter saying that there are certain amount of money in the form of interest which is still pending, and that has to be deposited. After I deposited, it was almost at nearing 15-20 days only was left, or a month was left for the tenure to complete. Then the buyer of a letter said that no, you will have to pay a prepayment penalty. I requested them, saying that since only 1 month is left, let me continue the account. Thereafter, I will close it, so that the prepayment amount, which is huge amount of money for me, so that prepayment amount is not levied. But they refused to do that. Ultimately, when they gave the final letter that the account was closed, it was after the tenure was completed. So chronologically, date-wise, even if their contention is right, their plea is right, that my first contention is that they are not at all entitled to prepayment charges. Because whenever the amount, there is zero debit balance in the account, they don't charge anything. So prepayment means what? It's a debit balance, zero debit balance only. So why now charge? Even they have taken over my facility from a State Bank of India. At that moment, the State Bank of India never charged me any prepayment penalty. They have taken it, and after that, from them, I went to another. I wanted to go to another bank. So my first contention is there cannot be any prepayment charge. Now, second is your lordship. Even if their contention that there will be some prepayment, the dates will show that when finally they closed my cash credit account, the tenure was already expired. Tenure had already expired. So there remains no question of paying any prepayment charge. So this is the two-folded argument for prepayment.
So there are two aspects. One is that cash credit.
Yes.
Is a system by which amount remains. You can take out.
Yeah.
And when you take out, then you have to pay the interest. If you don't take out, there's no interest.
And even if I give it back, whatever I have taken back, from that moment also,
there's no interest.
Yes. So prepayment is more like making it a zero debit balance. So how can they leave a charge on that?
So therefore, your submission is that if I have given it back,
yes,
where is the question of
any charge?
Any charge? Secondly, you say that you have given it, you ask them to continue for a month.
Yes.
So that the 1 year period will be there, but they did not do it. Yes. And thereby they close it and took this 2%.
And in fact, they didn't close it because there is one final letter which came after the expiry of the tenure. So there is question mark in that whether they have closed it or not.
When did they deduct?
They deducted yes, your lordship, they deducted it on one part I have paid myself, your lordship, and the other part they have deducted it from another account that I was holding in there without my permission. That is another contention in my.
No, that is okay, but when did they deduct?
Rupees 1 crore was like.
Or did you pay within the period?
On 1st of January 2016.
2016,
1st of January 2016, they deducted the prepayment charges.
So 1st of January 2016.
Yes.
And the sanction letter is 25/11/2014.
Which will expire on 25/11, which was supposed to expire on 25/11/2015.
15.
Yes.
So under such circumstances, they deducted after 1 month.
Yes.
That is
After
from the
1 month. Yes.
That is from the another account.
No.
That's a different thing. Yes. Intend to pay the amount, and closure cannot be proceeds.
that is a
No,
theft.
what your lordship is asking is
Theft
that.
by Axis Bank, no?
Yes. So I have another account without my consent. They just deducted it, and then they are showing me section 171 of contract account, saying that they have the lien on each and everything, even my personal things. So
that is 2%. And the bank guarantee is 1.5.
yes, the commission.
So there the commission is there.
Yes, commission.
What do you have to say on that?
Yes. Actually, to be honest, I have prepared for the cash credit. Has come up suddenly.
Fellow will hear it some other
Yes,
day.
yes.
Well,
Next Tuesday, Lordship. Next Tuesday, Lordship.
next Tuesday not possible. Next Tuesday. You can try a luck on 19th.
19, Lordship.
It's the matter again on 19th for further hearing.
Highly obliged.